maybe.
Chances that I have answers are very slim.
Yeah.
I was just gonna do a test if the speakers not working, but I heard it was really.
Maybe you say it's stuff.
Right, no, I feel like there's a lot of dramatic trauma.
You just turn the recording back on?
Yeah, it's like,
Typical, because it really isn't.
to pause that. Speaker works. What is it that you were scared of? I'm gonna give you that.
Just do it.
Loud.
You just met them.
Oh, you did?
I didn't. I welcome you to this meeting of the Maine Human Rights Commission. Before we proceed with the business of today, I'm asking each of you who may have an electronic device, cell phone, pager, etc., to ensure that they're silenced now. We have additional agendas, including the consent agenda available in the back of the room. The consent agenda is a listing of cases in which no written arguments were made to the commission in the allotted period. The commission has voted on those cases and will not be considered further today. The remaining cases on the agenda today are coming before the commission to determine if reasonable grounds exist to believe that unlawful discrimination has occurred. The commissioners have received and reviewed investigators' reports after some issues and on written submission submitted within the allotted time. No new information or any written materials will be accepted today. Cases will be called in the order of the accepted agenda. As I call each case, the party who has submitted a written argument will be called to the podium to provide the most relevant arguments to the case. The time is limited to 10 minutes and time may be reserved to rebut opposing arguments, but the time limit of 10 minutes may not be exceeded. Procedural rules of the commission specify that your arguments may address only 1, relevant factual errors, 2, relevant omissions from the report of facts submitted during the investigation, or 3, relevant issues and questions concerning interpretation of the law. The commission allows parties who do not disagree with the investigator's report to rebut comments made by the opposite party. Please be advised that commissioners may ask questions. I will ask that you introduce yourself.
Actually, we're not at that part, that we're just doing the business session right now.
Okay, yeah, all right.
So the first thing on the business session agenda is, before we have any, typically the first thing we do is a motion to adopt the agendas. But before we do that, there is a request for a complainant on the consent agenda today to have us issue a right to sue letter. So I ask that you address that first, because if you grant it, it will change the agenda. So you have a memo from me dated June 15th about a request for a right to sue letter at E210297. And I would ask that the commissioners, I've given in the memo, I've given my recommendation. I would ask that you make a determination about whether to grant the right to sue or not.
Well, I would make a motion that we do not accept the right to sue.
Not issue the right to sue.
Do not issue the right to sue. Yes.
Is there a second?
Second.
So as a reminder to folks, because we have people participating remotely, commissioners I'm required by our remote participation policy to ensure that every vote of commissioners can be seen and heard. So for every single vote, I will be polling the commissioners to get their vote. They need to signify that vote clearly and clearly. So the motion is to deny the right to sue request in E210297. If you're in agreement, you will vote yes. Commissioner O'Brien?
Yes.
Commissioner Walker?
Yes.
Commissioner Douglas?
Yes.
Okay. Julie, I'm just going to run with this unless
Yeah,
you'd like to do
please.
something else.
No, okay.
Next up is the minutes of the May 2023 meeting, and we will be looking for the commissioners to adopt those formally by vote.
I'll move that we adopt the minutes from the May 23rd meeting.
Second.
So any discussion? I forgot to ask that in the last one. Any discussion? Seeing none. If you're in agreement with the motion to adopt the May 23rd minutes, you will vote yes. Commissioner O'Brien?
Yes.
Commissioner Douglas?
Yes.
Commissioner Walker?
Yes.
Okay. Next up, the director's report. You have from me a memo indicating that there's been no changes in personnel since the last meeting. That's still correct. You have a memo that appears to be from me, but is actually from Kit Thompson-Crossman, that outlines the status of reasonable grounds cases. And since the last meeting, there have been 2 unsuccessful conciliations, no successful conciliations, and there are 4 conciliations still pending, still active. There haven't been any agreements. There is one post-conciliation agreement that I guess we can take during litigation. So I'll present that to you in a bit, or after we do the litigation discussion, really after executive session. You also have a memo. This one is from me, doesn't say anything, but outlines case activity from May 2023, a little chart. And it says that in May 2023, we received 50 new complaints. We resolved 77 cases. Of those resolutions, 6 of them were administrative dismissals. 4 of them were right to sue requests. 33 of them were either settlements or withdrawals with benefits. And the total to complainants as a result of those settlements or withdrawals with benefits was just over $500,000. Next, I would suggest that we take litigation after executive session. And for new business, I'll try to just let you know quickly, but there actually is new business. One is an update on the legislature, which is trying desperately to wrap itself up. There are a number of bills that relate to the Maine Human Rights Act. A number of them have been signed into law to allow the commission to issue right to sue requests before 180 days in some circumstances. There was an act to increase the and none of these came from our agency. Well, there's been an act to increase the damage caps in matters relating to the Maine Human Rights Act. That was signed into law by the governor.
What are the caps?
I know yours into somebody who can help you that.
Well, no, never mind then. Never mind.
I think that our esteemed legal counsel can answer.
Nice. This is a Passover. I should have seen it coming, and yet, no.
While she's pondering
Yeah,
that.
while I'm looking that up. Don't care.
Tire tracks and just.
Yeah, yeah. The one bill that did, that's just rude. The one bill that did come from us, actually, no, it didn't come from us. There's a bill to, you know how we have been trying to enact regulations related to schools. Once we finally updated our statute to be consistent with the rest of the Maine Human Rights Act, we've been trying for many years to get rules enacted. We haven't been able to. There was a resolve passed, signed into law by the governor, wasn't ours, to require the commission and the Department of Education to work together to pass rules now and every 10 years. So it's a resolve.
They bumped it up to every 10 years?
I think so. That's what I recall. So there's no consequence in it, but it did pass. So that's probably a good thing.
It changed to.
Yes. Yep. There's a couple bills that were bumped over to the next session, like the Fair Chance Housing Act, which would take, like it's called Ban the Box, which would take the question about criminal convictions off of initial applications for housing. The bill to include public entities in all of the provisions of the Maine Human Rights Act. Right now, it's just public accommodations, and only disability is the only protected class for a public entity. So to be clear, what that means is places and services owned by the government, but not open to the public, which generally speaking means correctional facilities. That passed, but is sitting on the appropriations table fighting for funding with lots of other important bills. And it will most likely die there. And another bill which was signed into law is a bill that we didn't initiate that. No, the Attorney General's office initiated that. To amend the Maine Human Rights Act definition of educational institution to include single-sex educational institutions. Barbara, you want to briefly summarize that one?
It actually amends the Human Rights Act to eliminate the exception to the Human Rights Act for single-sex
There are many, are there?
There are no single-sex schools right now, so this conveniently
It just closes
upsets
the loophole.
nothing. There was way back when the education provisions were first enacted, they only covered sex. So there was an exception for single-sex schools because the only thing they could discriminate in was sex, and that was essentially their entire program. Many amendments later, nobody touched this exception. Everyone forgot it was there. And it has recently been brought to people's attention again in connection with some litigation. And when we noticed it, there was a push to amend it. So we closed the loophole because there's no reason a single-sex school should be able to discriminate on the basis of, say, race. So they eliminated that.
Okay.
And in perhaps the most exciting development, as of Saturday afternoon, as you may recall, we've been trying to get positions for forever. And there were 2 positions in the governor's budget that were included, but we had no way of knowing if they would actually stay in the budget. And on Saturday afternoon, those 2 new positions were moved into the budget by the Appropriations Committee. So one is a business manager position that we desperately need because the mediation program billing and accounts receivable is very time consuming. And the other is a new investigator position. And here's why all of that is so important, especially getting increased staff, is our housing caseload it's been going up every year. More and more housing cases. It could be part of the housing crisis. It could be related to the pandemic. It could be all of the above. But every year, over 3 years, more than that, housing cases have been going up and up. And you've seen from investigators how much detail needs to be in housing cases and the addendums. And that's only the half of the requirements of the 100-day deadline for housing cases. The push for housing cases has had such a huge impact. It's so resource intensive that it has decreased our ability to address other cases. So we have 2 contracts with federal agencies. One is with HUD for housing cases. One is with EEOC for employment cases, right? We had to tell EEOC this year that we could not get to a quarter of the cases we were expected to close. So we had to cut our contract by a quarter because housing cases are so demanding. We just don't have the resources. So it's EEOC is that they're not bad. It's fine. It's just a fact. Lots of agencies ask to have their contracts adjusted downward. We've in the past asked for a case or 2. Usually we ask to go up. We've never asked for a cut like this. So that tells us there's something really intensive going on. So it's good timing that we have the additional staff. We also have an RFP out right now, a request for proposals for our mediation program, mostly because the Division of Procurement required us to do so. We are in the process of reviewing and scoring. There's an unbelievably detailed set of requirements for that. And finally, on new business, you have a memo for me about our 2024 meeting schedule. And I know it seems insane to be planning that now, but we do it in order to reserve this meeting space. Because if we put it out there ahead of time, then it's just locked in and we know that this space is reserved for us. And it lets you adjust your schedules accordingly so that you know when the meetings are. So even though it is not required, I would ask that you approve that meeting schedule. If you are inclined to do so.
I would move that we accept the 2024 meeting schedule.
Second.
Any discussion? Seeing that, if you're in agreement with adopting the set forth 2024 meeting schedule, you'll vote yes. Commissioner O'Brien.
Yes.
Commissioner Walker.
Yes.
Commissioner Douglas.
Yes.
Okay, that's all we have for new business. And since we are running 5 minutes late, I would suggest that we head into the morning cases. Julie, do you have the agenda?
Yeah.
You want me to do the, You want,
I'll call.
all right, good.
Let me just try it.
Yeah.
Okay, the first case is E210191 Davis versus, no,
Oh, yes, you're absolutely right. Totally right. Sorry.
okay. Round one entertainment.
And it's a no reasonable grounds case.
Yes, no reasonable grounds case, so go ahead. Go ahead. Okay.
So we would have complainants or their representative come forward first, and we ask that everyone, when you do come forward, whether it's on Zoom or in person, that you introduce yourself. And also remind everyone participating not to use the names of third parties. In our reports, we've given them pseudonyms. The Maine Human Rights Act requires the commission to maintain confidentiality. So we're asking you to do that as well, of third parties. So Kaylee Davis.
Good morning.
Yes.
I'm Eric Peters. I'm here for Ms. Davis.
Yes.
Assuming you'd like me to keep the mask on?
No, you can take it off when you're presenting. Thank you for asking. So let's look for last row.
I think it's pronounced Adriel.
Adriel. Adriel.
Good morning. Joshua Nedro for the respondents.
Okay, we're just gonna pin you on there, but you can go ahead, Mr. Peters.
Thank you. Good morning, and thank you for the opportunity to address the commission. I'm Eric Peters on behalf of Kaylee Davis. Our position here is pretty simple. This is a reasonable grounds case, and with no disrespect intended for Investigator Morse, her report failed to analyze key evidence, contained some errors of law, and mistakenly concluded that round one entertainment did not discriminate against Kaylee Davis on the basis of her religion. Kaylee is a devout, non-denominational Christian who, like many, engages in religious observances that prevent her from working on certain weekend days. When round one hired her in 2018, she not only made them aware of this, she would not have accepted the job they offered had they not agreed to this accommodation. That's undisputed, as is the fact that round one granted Kaylee her requested accommodation. It's also undisputed that when her new supervisor, who I'll refer to as Mr. C, in accordance with what the directions we were just given, took over in March 2020, had questions about this, rather than contacting the company's HR department, he aggressively questioned Kaylee about it. Mr. S, respondent's loss prevention director, later described this behavior as, quote, inappropriate. Correctly, Kaylee perceived her supervisor's questioning as harassment and reported it to round one. However, the company did nothing. Subsequently, Mr. C conducted Kaylee's performance review and downgraded her in its leadership and responsibility section. In a phone conversation he had with Kaylee, he admitted that he did so because of her religious accommodation. He also admitted this in an email as part of the record, stating that, quote, the leadership and responsibility portion of your evaluation is scored and based off your ability to be available during our busy times. It's undisputed that the only thing that impacted Kaylee's availability during round one's busy times was the religious accommodation the company granted her back in 2018. The report also failed to analyze the effect that the numerous other incidents of harassment that Kaylee had to endure after she reported her supervisor had on creating a hostile work environment. We cataloged a number of them in our complaint and in our submission last month in response to the investigator's report. They included her supervisor speaking negatively about Kaylee to Ms. C, a round one employee at another store he managed, about Kaylee's job performance and about her religious practices. Her supervisor also publicly and falsely accused Kaylee of tampering with documentation and of falsifying payroll documents. The report also failed to analyze statements from round one's loss prevention director that both Mr. C's comments to the coworker, Ms. C, about Kaylee and the manner in which he questioned her about her religious accommodation were, quote, inappropriate. That round one was going to provide Mr. C, Kaylee's supervisor, with coaching and counseling related to his behavior. That Mr. C would no longer be Kaylee's direct supervisor or round one's manager for Maine. And then round one was going to provide coaching to anyone who supervised Kaylee so that what she experienced from Mr. C never happened to her again. The report also failed to analyze Mr. S, the loss prevention director's statement that if it were up to him, he would change the leadership and responsibility evaluation score, the one her supervisor lowered due to the religious accommodation. Finally, the investigators' report also failed to analyze the evidence of the physical and mental distress and need for mental health counseling that her supervisor's behavior caused Kaylee. And as we've pointed out for almost 2 years, respondent has offered literally no argument or evidence whatsoever in response or in opposition to Kaylee's hostile work environment claim. In light of that, the report's conclusion that she failed to meet her burden to prove a hostile work environment is incorrect, and the commission should reject it. Even if the commission disagrees, however, there are alternate grounds to conclude that this is a reasonable grounds case. Because contrary to the report's conclusion, Kaylee met her minimal burden to establish a prima facie hostile work, met her minimal burden to establish a hostile work environment for purposes of making a prima facie MHRA retaliation claim. Additionally, the report also mistakenly applied the adverse employment action standard from the Maine Whistleblowers Protection Act to Kaylee's MHRA retaliation claim. There's a significant difference between adverse employment actions in MHR retaliation claims and in claims asserted pursuant to the Whistleblowers Protection Act. An adverse action in the context of a general MHRA retaliation claim like Kaylee's means an action that could well dissuade a reasonable worker from making or supporting a charge of discrimination, while an adverse employment action in the context of a whistleblower retaliation claim means an action that materially changes the conditions of an employee's employment. Compounding its erroneous conclusion that Kaylee failed to establish a hostile work environment, the investigators' report mistakenly analyzed Mr. C's harassment of her through the prism of the Whistleblower Protection Act's adverse employment requirements and concluded that although Kaylee engaged in protected activity, quote, she was not subjected to any adverse employment action as a result. This was wrong as a matter of law. Adverse actions in the context of a general MHRA retaliation claim like the one here include subjecting an employee to a hostile work environment. The report did not analyze Mr. C's months-long harassment in the hostile work environment he created as it related to Kaylee making a prima facie MHRA retaliation claim. Similarly, the report did not address whether Kaylee's supervisor's actions might have dissuaded a reasonable worker from making or supporting a charge of discrimination, nor did it address the evidence of the actual effect upon Kaylee's coworker, Ms. C, that her supervisor's action had. Specifically, I'm referring to Ms. C's statements that after Kaylee's supervisor, Mr. C, spoke negatively about Kaylee's religion and job performance, it was intimidating for Ms. C to hear that he was unhappy with her and that Mr. C's statements definitely gave Ms. C pause. These were errors of law. Establishing a prima facie case only requires, quote, a small showing that is not onerous and is easily made. Once a prima facie case has been presented, an inference of discrimination arises and the employer is then required to offer a non-discriminatory reason for the employment actions in question. As indicated, round one has not even attempted to do so. Then the burden shifts back to Kaylee to show that the adverse employment action was a result of discriminatory animus. Evidence that the employer's stated reasons are pretextual can be sufficient to infer discriminatory animus. Kaylee provided reams of evidence that respondent and her supervisor subjected her to a hostile work environment after she reported his religious discrimination. For example, as part of lowering her review score in his campaign against her, he openly admitted that he did so because of her absences due to the religious accommodation that round one had granted her. Additionally, all of the other actions that Mr. C took against Kaylee, which respondent never addressed nor explained, postdated her complaining about his religious discrimination and harassment. Respondent never denied that this harassment occurred, and it subsequently punished her supervisor for his illegal behavior and required him to undergo training because of it. Finally, not only is there evidence that his actions could well dissuade a reasonable worker from making or supporting a charge of discrimination, as noted in Ms. C's statement, there is evidence that this actually occurred. Kaylee has met her burden to show that her supervisor discriminated against her because of her religion and retaliated against her for complaining about it. Respondent allowed this harassment to go on until she had no choice other than to resign. Accordingly, complainant respectfully requests that the commission conclude that there are reasonable grounds to believe that discrimination occurred. Thank you again for the opportunity to join you. I'm glad to answer any questions that you might have.
Questions from commissioners at this time for Attorney Peters?
Yeah.
Thanks for the heads up.
Yeah, okay, then you'll have about a minute and 3/4 left when we come back to you.
Should I sit down or do you want me to stay here?
No, if you have a seat, that would be great. I'm sorry, that computer, what I meant was, yeah.
Understood.
And then we have Mr. Nedro, and I'm sorry, I have probably butchered that.
Much closer than others. Good morning, Joshua Nedro for the respondents, Round One Entertainment Incorporated. Respectfully, we would urge the commission to adopt the investigator's finding of no reasonable grounds as to both counts. And before I get into, excuse me, the legal substance, I think the facts here are important. I heard Attorney Peters use the word undisputed a number of times, and we might have a disagreement as to what that means. The facts here are that Miss Davis was hired in 2018 as an amusement manager, a mid-level manager in the Portland restaurant. And at that time, she was granted an accommodation. That part is not disputed. She was granted accommodation to not work certain Sundays in accordance with her religion. It appears that this accommodation was granted by one of Round One's employees in California while she was attending onboarding training. Miss Davis was by all means a very productive and efficient employee. She was promoted several times, ultimately promoted to the position of general manager in December of 2019. And that promotion is important for a number of reasons. One is she's no longer a mid-level manager. She's the one in charge. She's the most senior employee at the restaurant in Portland. And coming with that additional duty, additional title, are additional responsibilities. One is, she needs to be available if anything comes up, whether it's customer complaints, whether it's employment, subordinate employee issues. And so she excels in that role too, from December 19th to December 2019. In February of 2020, she comes under the leadership of a new district manager, Mr. C. And as Mr. C is preparing and going through the evaluations of his subordinate, Mr. C was responsible at that time, I believe, for 3 different restaurants, 2 in Massachusetts and 1 in Maine, realizes that Ms. Davis hadn't been working on Sundays for a number of months, but did realize that she had worked on Sundays for a period of months leading up to this. So essentially, she had worked a number of Sundays and then stopped working Sundays. Mr. C investigates that and asks Ms. Davis, why aren't you working Sundays? That is our busiest time. This is a restaurant where there's arcade and bowling and that sort of things. And the weekends tend to be the busiest days of the week for obvious reasons. And she responds very hostily. She takes the position that Mr. C's inquiry into her not working on Sundays must be as a result of some sort of discrimination. Mr. C is obviously taken aback by that. This communication was done by email. It is in our position statement, and essentially results in Ms. Davis accusing him of discrimination. Mr. C outlining that he's just trying to figure out why she wasn't working Sundays, asked if an accommodation had ever been approved. At this point in time, Ms. Davis never says, oh, yes, so-and-so approved my accommodation when I was on onboarding training in California 3 years ago. She instead is hostile. She doesn't respond. Meanwhile, this leads us into February, March of 2020. The restaurant business, as no surprise to the commission, was forced largely to close in March of 2020. So while the manager had intended to continue the dialogue with Ms. Davis over the coming weeks, everyone goes home because the restaurant's closed. Restaurant reopens in July 2020, partial schedule, couldn't be open certain hours, couldn't do certain activities based on Governor Mills's executive orders. And everything kind of goes back to normal. Scheduling on Sundays isn't as important due to the reduced scheduling. She gets an evaluation in August of 2020. No complaints there. Fast forward, she gets another evaluation in February 2021. This one contains the same exact score in the category that she believes has something to do with her availability. and she raises an issue with it. She says, no, you're giving me an 8 of 10 on this one piece of a 10-part performance evaluation. It must be because I had taken some Sundays off. The response is, no, it doesn't have to do with that. We just need to be available. And it had other, labor control, statistic, data points that she was being ranked on. It had really nothing to do with whether she was in the store or not. But at the end of the day, she received the exact same evaluation, 8 of 10 ranking on this piece. She also received an S as a letter grade, which is the highest ranking she could have gotten out of this piece of the performance evaluation. But nevertheless, she protests, now claiming, a hostile work environment that after her complaint in February, a supposed complaint in February 2020, that she was treated differently. I think the investigator's report outlines that she wasn't treated differently. She was managed. It's not unusual for a manager who has been accused of harassment by a subordinate to request that conversations between the two be in writing or other sort of permanent means versus telephone. And at bottom, what Mr. C is accused of doing is simple managerial tasks over a subordinate employee. I heard Mr. Peters say that, we haven't tried to rebut a hostile work environment claim. We did. We addressed it in our position statement in a footnote, saying that there just isn't the level of severe pervasive activity to alter the terms and conditions of her employment. The investigator obviously agreed with that assessment because what she complained of were simply being managed by a manager. With respect to the retaliation claim, again, no adverse action here. She received the same exact evaluation she did prior to making the complaint. And, this is really a case of, what should happen. She did raise an issue. It was investigated. The company didn't believe anything unlawful had occurred, but recognized that there was value in removing Miss Davis from Mr. C's chain of command. They did so, and then they granted her accommodation. She had requested to not work certain Sundays and certain holidays as a result of her religion. That accommodation was granted in March of 2021. About 3 weeks after it was granted, Miss Davis resigned, without notice. And so, the lesson here is the company took her seriously. It never discounted her evaluation as a result of her religious practices. And despite having a new job that required additional responsibility, they renewed the accommodation post-promotion. Unless there's any other questions, I will defer the rest of my time.
Thank you. Commissioners, we've had Commissioner David join us. I'm not sure if Commissioner David, if you've heard all of the arguments.
Yes, I was listening to them on YouTube as I was getting here. So I have heard all the arguments.
Great.
I'm sorry for the disruption.
It's okay. Any commissioner questions for respondents council at this time?
I just have one question. So I'm looking at this email dated February 12, 2021 from Jared. And it says, it's to Kaylee, and it says, when you were hired, we never approved for you to make your own schedule and take weekend days off. And I just want to be clear, is that accurate from your perspective?
Yes. So the date of this email is important, February 12th, 2021. The prior accommodation was not discovered until during the litigation. We had asked Miss Davis, or the company had asked Miss Davis during this period who had approved it, and she had never disclosed that. So at the time Mr. C wrote this email, he was under the belief that no accommodation had been approved. And further, no accommodation had been approved following her promotion to general manager.
Yeah. But at some point there was an accommodation that was approved that folks just didn't know about. True?
That's correct, because Miss Davis did not disclose it.
All right. Thank you.
Sorry, any other commissioner questions for respondents council at this time? Seeing none. And Commissioner David, just so you know, we can't see your picture in large size right now. So if you do have a question, please give us a shout out, because we can only see one large picture at a time. So I'm not seeing you raising your hand, so I'm guessing you don't.
Understood.
Okay. We're not at our utmost in technology today. So then Mr. Nadro, you'll have about 2.5 minutes when we come back to you. Mr. Peters, you have about 1.75 minutes.
Thank you. I will be fairly brief in discussing the comments that Mr. Nadro just made. First, Kaylee never tried to hide that she had this accommodation. Round one gave her this accommodation. And instead of reaching out to the company's HR department, and by the way, this is not a mom and pop shop. This is not like a convenience store by the side of the road. This is a multinational company that has hundreds of employees and dedicated HR employees. Instead of reaching out to them, he hostily and aggressively questioned her about it in a manner that made her feel as though she was being harassed. And Mr. Nadro mentioned about whether certain things were undisputed or not. There's no dispute that they gave her this accommodation when they hired her. And as I said earlier, she wouldn't have taken the job had they not given it to her. She also served in this new role for 4 months before the supervisor began harassing her about the accommodation. So clearly there wasn't any issue with the transition from old job to new. And then finally, this idea that there was some other reason for her missing time besides the religious accommodation is ridiculous. There's never been any evidence that they've put forward that she was unable to be there during their busy times, other than the religious accommodation they granted her. Okay. And this score that he marked down, you got the email in front of you where he says it's because you're not here at our busy times. Doesn't say it's because of labor costs or any other thing. So he says to her, it's because you're not here. And the only reason, and I'll use that word again, and it's undisputed, the only reason she couldn't be there was because she was taking certain days off because of her religion, an accommodation that granted her at least 2 years prior.
I just cut in before you run out of time.
He actually did.
I think I just ran.
All right, I'm a little confused about this at this point.
Sure.
The score was the same, right? Was the score the same?
So let me ask you this.
And in a broader sense, what's the adverse employment action?
So I'm going to answer your second question first.
Yeah.
The adverse employment action is the hostile work environment that's created. And that's why I went into the little primer, which to me, there's a case from the U.S. District Court, Charette versus St. John, it's cited in our materials, that talks about this distinction between adverse employment actions for purposes of an NHRA retaliation claim like ours versus a whistleblower claim. So it doesn't have to be you're fired, you've got a worse shift, we cut your pay. It includes creation of a hostile work environment. And that's key, both substantively and also because of the minimal burden Kaylee had to establish a prima facie case for retaliation. Now, the score issue, let me ask you a question. If I give you in 2022, I'm your supervisor and I give you an 8 and you think, you know what, I'm an 8. I'm not complaining about my score. And in 2023, I give you an 8 and you think that you're a 10. Would you then comply? I mean, he says both verbally and in writing, I'm knocking you down because you're not available during our busy times. And that's because of the religious accommodation. Okay. So the score should have been higher. And when they say that, I think Mr. Nadro cited to the letter grade that says it was perfect. Well, it's not perfect. I mean, it's an 8 out of 10. So she should have gotten a higher score. She didn't because of the religious discrimination. That's part of the hostile work environment, along with, managing someone hard or managing someone does not include denigrating their religious practices to a coworker. It does not include lying about them falsifying documents and payroll documentation. And that's just one of the myriad of things that we cited to in our complaint and in the other things that we filed in the succeeding 2 years that this has been in front of the commission.
Any other commissioner questions for Attorney Peters? Seeing none, thank you. Thank you. And then Chelsea, thanks for pending Attorney Nedrow again. You have about
Thank you.
2.5 minutes.
All right, I hope I don't need that whole time. I'll just try to address the 3 sort of main points I picked up from Attorney Peters' presentation. There was no paper or documented record of the initial accommodation from 2018. Group 1 did not learn of that accommodation until Ms. Davis disclosed a name of an employee who they believed or who she believed had approved it, and that person was contacted. That's the only reason we even know that that happened. It's not unreasonable for a manager to ask, particularly following a promotion to a new role and where there's a new supervisor, to confirm an accommodation or to inquire about it. I keep hearing that Mr. C was aggressive and hostile and harassing towards her. You have the communications. They were all in writing. Mr. C's tone is not disrespectful. He's inquiring about why one of his general managers is not working on one of the busiest days of the week, in the context of having just completed a 3-month stint where she worked nearly every Sunday. The schedules are Exhibit 7 to our position statement. It shows that she was working Sundays with some routine. Group 1 does not take the position that Ms. Davis was trying to take this time for some other purposes. We're not challenging the legitimacy of her religious belief. All we are saying is that a new manager was inquiring as to why she went a period with working Sundays and then all of a sudden stopped. In terms of the hostile work environment and the adverse action and the retaliation, it's somewhat circular. But again, I will relay, that most of the communications in this case were done in writing, for better or worse. You can see what is being said between the parties. If there's a party being particularly aggressive, I would say it's Ms. Davis in her response to what are legitimate and legal inquiries from a manager about the need for time off. I'll yield the rest of my time. Thank you.
Thank you. Commissioner, questions for Attorney Nedrow?
Yeah, I guess I'm just wondering if you could say a little bit more about what Attorney Peter said, the hostile work environment, basically accusations being made and communications going back and forth. I mean, in basic terms, it sounds like we're trying to sort of gin up a reason to have an adverse employment action or demote her or fire her or something along these lines. Can you speak to that?
Yeah, I would say absolutely not. There was no desire to terminate her at any point. In fact, the company, was disappointed when she resigned. I think as you go through the communications between Mr. C and Ms. Davis, it's just trying to understand why she isn't there on Sundays and what the company can and can't do around that issue. There's other emails attached to our position statement, particularly one from March of 2021 between Mr. C, Mr. K, who is a more what I call organizational HR, and a Mr. O, who is in some executive function. And Mr. C is asked straight up, why did she receive the 8 of 10? He responds, well, here's a spreadsheet. Here are, our labor scores. Here are the issues that I ranked her on. The idea that she was being ranked because she wasn't there is a misinterpretation of a comment made by Mr. C earlier. No one was searching for grounds to terminate Ms. Davis. And in fact, I think the record shows that after she complained and it was investigated in early 2021, she received the accommodation she requested. And the company agreed to remove Mr. C from her chain of command because they saw that there was a personality conflict there. The company didn't necessarily believe that anything unlawful had happened, but they're wise enough to know that they can eliminate potential situations where additional inappropriate or conduct that Ms. Davis feels was inappropriate could happen. And so from that point on, she reported to Mr. O, who was then the Eastern Regional Director and in essence Mr. C's boss. So the company wanted to keep her employed. She was a good employee. She did a good job. And I think her evaluations show that she did a good job. She received these perfect rankings, 8 of 10, 9 of 10, 10 of 10. Those 3 rankings go into the evaluation the same way. So there's no material impact on an 8 versus a 9 or a 10.
Thank you.
Any other commissioner questions for Respondents Council? Seeing none, thank you. So next we would hear from the investigator.
Hi there, my name is Angela Morse. I'm the investigator who was assigned to this case. Through my investigation, I did not find that the complainant met the burden to show that there was a hostile work environment or that, and she did not substantiate that retaliation occurred. Certainly willing to answer any questions.
Any commissioner questions for the investigator? Not seeing any immediately. Okay, thank you, Angela. So commissioners, you've heard from the parties and from the investigator. At this time, we would be looking for a motion. There is one proposed finding. Walker?
I would move that there are no reasonable grounds to believe that Round One Entertainment discriminated against Kaylee Davis on the basis of religion or retaliated against her in violation, and that the complaint should be dismissed.
Second.
So it's been moved and seconded. Is there any discussion?
Yeah, I mean, I think it's a close call, I think, and I mean, I'm troubled by this business about the company not knowing about the accommodation. As Attorney Peter said, this is not a mom and pop business. You know, the employee should not be solely responsible for being able to report the accommodation to the employer. But it just doesn't seem like Ms. Davis suffered any adverse employment action or any other difficulty with her employment that rise to the level needed. So I think it's a very close case and a tough case.
Any other discussion among commissioners? Commissioner David? Did you have something you wanted to?
Yeah, yes, I agree that it's a close call, but I don't find that that it's a hostile work environment on the definition of severe or pervasive. And so I'll be supporting the motion.
Any other discussion among commissioners? So the motion is to find no reasonable grounds to believe that unlawful discrimination or retaliation occurred. If you are in agreement, you will vote yes. Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Commissioner Walker?
Yes.
Commissioner Douglas?
Yes.
So the findings are no reasonable grounds. We appreciate the parties and attorneys' participation. The commission will send a letter confirming the results. Now, Commissioner David, do you want to take over chairing?
No, I don't. Julie's doing a good job, and
Okay, that's not what she expected to hear. No. If it is helpful, I'm just gonna keep on running through.
Yeah.
Is that
Yeah.
easier?
yeah, I think Julie should continue to do it. I think it's awkward to do it remotely, and I apologize, Julie, that you had no notice whatsoever of this, but I think she ought to continue to chair, please.
There you go.
Thanks, Ed.
Do you want to call the cases or do you want me to call?
You can.
Okay, all right, got it. So the next case, and everyone heard that, it's not just me being bossy. She asked me just. The next.
Nobody thinks you're boss.
Everyone thinks I'm boss. And the next case is PA 21-0227/8, Jared and Gavin McKenna, there's the Department of Health and Human Services, Office of Aging and Disability Services. Since this is a no reasonable grounds case, we would be looking to hear from complainant or their attorney first. I believe that is Attorney O'Meara.
I did not recognize you behind that.
Who is that last name?
You'll have 10 minutes, sir.
Morning, Commissioners. My name is Richard O'Mara. I'm here today on behalf of Steve and Carrie McKenna, along with my co-counsel Ellen Masalski. Steve and Carrie are the parents of two young men in their 20s, Gavin and Jared, both of whom have significant disabilities. Each requires round-the-clock one-on-one care and is eligible from the DHHS waiver, Section 29 waiver program to receive that care and be funded. They're both approved for something called the Shared Living One-Member Service, which means each of them has a shared living provider who lives with them and provides their direct support. This case is about associational discrimination. You'll see the report from the investigator, and we don't really disagree with the report because it's on a different issue. The issue that's missed in the report is the associational discrimination. Section 4592(6) of the Human Rights Act says that a covered entity, like in this case, DHHS, may not exclude or otherwise deny equal goods, services, facilities, etc., to any individual because of the known protected class status of another individual with whom they're known to have a relationship or association. In this case, the only reason that DHHS denied each of these young men their full services, and in fact offered them either half services or the chance to move away, was because they lived in the same house with each other. If they lived in separate homes, DHHS takes the position that they each could have had full-time, round-the-clock services from a shared living provider. If they lived together, then they were grouped together and they were told that they had to share the services of one shared living provider, and therefore would get half the services, half the stipend would be paid for their services. And so what the issue is in this case is there a violation, section 4592(6), because each of them, by virtue of choosing to live with another individual with disabilities who also receive services, had to take a cut, had to be cut in half, or that person would have to move out so they could each get full services. And in fact, it was suggested by the department that if one of the parents moved out of the house and set up a different residence across the street, wherever, they'd be happy to give them each full services. But here, full services were denied because they chose to associate and to live together. This was the subject of a Medicaid benefit manual rule that said you couldn't do this. Basically, the rule itself is discriminatory. It says you can't have two members receiving full services in the same home. McKenna's position throughout this was misinterpreted because the word in the rule does not say home. It says in the same arrangement. A Superior Court justice heard that part of the case and ruled last year that arrangement does not mean home. Arrangement means the relationship between the provider and the person receiving the services. So Justice Douglas on our Supreme Court said it was perfectly allowable under this rule, and it's the correct interpretation of the rule, for the department to allow full services for each of these young men, each served by one of their parents in the same home that they've grown up in. Unfortunately, Justice Douglas's ruling does not answer the question we're coming to you with today, which is, does this also violate the Human Rights Act? This interpretation by DHHS that you could not be in the same home with another person with disabilities and receive your full services violate the act. We say that it does. 4592 section 6 specifically says that. The facts here are not in any dispute. Everybody agrees both young men are eligible for full services. Both of the providers, their two parents, are fully qualified. Their home has been approved. The only issue is, are they at one site living together, in which case they get half, or are they in separate locations, in which case they get full. Another interesting fact in this case is there's a third brother in this family who does not have a disability. He has come in and out of this home throughout this period of time this has been a dispute without any effect. So it doesn't matter if the person lives with a non-disabled person in their same home. That doesn't affect their benefits. What affects it? Living with another person with a disability. And we think that's the key to the association claim here. They were treated differently because of the fact that they chose to live with another person with disabilities. The report that investigator Brindley did lists out the facts and then goes off to say were they discriminated against because of their disability. Each of them has a disability. And the report concludes no reasonable grounds because it's not disability discrimination. We're not contesting that. This is not a disability discrimination case in that way. The disability that matters here is not of the complainant, but of the person the complainant chose to live with, the associational part. And we believe that if the proper legal analysis had been done under the associational provision of the Act, then reasonable ground should be found. And that's what we're asking for today. Happy to take any questions.
Thank you. Commissioner questions for Attorney O'Meara? None at the moment. You'll have about 4.5 minutes and we'll come back. And then we would look to hear for any more.
Commissioners, my name is Kelly Morrow and I represent the Department of Health and Human Services. I just want to kind of give a framework of shared living for you before I get into the argument, and so there's an understanding of how it works. Shared living is a Maine care service under Section 29. Basically, there's an approved service location, usually a home owned either by the member or by the shared living provider. The shared living provider serves as a direct support professional who has to be certified to provide the services to the member in the home. The DSP, the direct service professional, has to contract with a third-party administrative oversight agency to be paid for the services. And the department reimburses the administrative oversight agency for those services. Now, the amount that the direct support professional receives is negotiated between the administrative oversight agency and the direct support professional. The department isn't involved with that. In this case, the shared living rule that was in dispute is in the Maine Care Benefits Manual. And the rule says only one member may receive services in any one shared living arrangement at the same time, unless a relationship existed prior to the service arrangement and the arrangement is approved by DHHS. The word in dispute in this case was, what is the definition of arrangement for shared living arrangement? And as we know, the Superior Court did disagree with the department's interpretation ultimately. The department interpreted that word as meaning home. So pursuant to the department's determination, one DSP would be at the service location serving one member. And that was what was contemplated by the department. And the exception to that was if there was a member who was related or was a good friend, that member could also receive services by that DSP in the home. The reimbursement rates associated with the services it's $156 per diem for the DSP serving one member and $78 per diem per member if there are two members in the home. And that was the reimbursement rate that was approved by the legislature. It's in the rule. And that reimbursement rate contemplated that by the department allowing two members to be served by that DSP in that home, there wouldn't necessarily be double services provided by that one DSP based on economies of scale. The DSP, maybe makes dinner for both people. It's not making dinner twice. Other tasks that can be performed at the same time for both members. So that was what was contemplated by the department's interpretation of the shared living rule. And the reason for that was potentially if arrangement at the time were interpreted to be relationships, potentially there could be multiple DSPs at one service location serving multiple members, creating a group home type situation, which is not the shared living model. So that was kind of the reason behind the department's interpretation. And again, we know the Superior Court disagreed with that interpretation, and the department has since awarded the McKenna's or agreed with the McKenna's interpretation in this case of the shared living rule. So there are two arrangements at the McKenna residence. Both Jared and Gavin are receiving services from Mr. and Mrs. McKenna and are receiving $156 per, I think it's $156 per diem at this point, unless the reimbursement rate has changed. But and they are contracting with their administrative oversight agency to be paid for those services. So, and I believe that's been happening since July of last year after the Superior Court issued this decision in this case. As Attorney O'Meara said, the Superior Court did not make a finding that there was any discrimination. We're looking at an error by the department in the interpretation of the rule. An error doesn't necessarily mean it's discriminatory. The department has to ensure that its rules are applied consistently, that there are enough benefits to go around, basically. There are eligibility criteria under the rule. And in this case, the complainants are alleging associational discrimination. The department is not saying, they're not dictating who they can live with. Jared and Gavin could have lived together. They did live together. They could have both received shared living services from Mrs. McKenna, who was the DSP at the time, and I believe they were. So the department doesn't dictate who they can live with, but when people apply for certain services at certain service locations, the department has the obligation to determine eligibility under the specific rules of that program if they want those specific services. And in this case, there were other services potentially available. Home support quarter-hour services. We do acknowledge that there has been a shortage of providers to provide those services, but that wasn't a potential option here. So the department's determination was not based on who was living with who, but based on what services were being requested at that particular service location. I believe that we would urge the commission to adopt the investigators' recommended finding no reasonable grounds here, and I'm happy to take questions.
Mr. Ryan?
I want to be, I'm sure I heard you correctly, that the rule since July has been changed.
Well, the rule hasn't been changed, but the interpretation in this case.
Okay, so this is specific to this case?
Well, I think going forward, it's going to be taken on a case-by-case basis, depending on what the situation is. I think, because potentially you could have a situation like I described, where you have maybe multiple members requesting services at one location with multiple DSPs. And I think that, that would defeat the purpose of the shared living rule.
So you are saying that it is now a case by case?
I think the department has always been a case by case, but yes, I would think it would be a case by case going forward, because it would depend on the situation to determine eligibility for a particular program.
Thanks.
So Attorney O'Meara claims that the investigative report in this case is sort of misses the mark. And analyzing this from a disability discrimination standpoint, which should be an associative analysis. Do you agree with that?
Well, I do agree that the complainants allege both forms of discrimination in their complaints. I think ultimately the question is the same. Was the department's interpretation and application of the rule discriminatory, either based on their own disabilities or based on their association with someone with a disability? And I think the answer is no to both of those questions.
Okay, so I mean, if Attorney O'Meara is right, and this should have been analyzed from an associational standpoint. I mean, isn't it also correct that there could be discrimination here? I mean, these people are basically being discriminated against because they live together, right? They cannot receive the services that they want because they live together. Isn't that correct?
Well, the department's position at the time was no, they could receive the services they wanted, because under the shared living model, you can have two members in the same home receiving shared living, just needs to be by one DSP. And the reimbursement rate is the same, because there would not be double services being provided.
Thank you.
Commissioner Davis? David?
Yeah, thank you. Are you saying, counsel, that the case is moot now? That you've changed the interpretation in accordance with the Superior Court ruling, and so that there's no longer an issue?
I'm not saying it's moot. I'm sure the complainants would not say it's moot. But I am saying.
Well, I guess I missed the opportunity to ask that of complainant, and I will, but what is your response?
I'm not saying that it's moot. I don't think we're saying that it's moot. We're just saying that there was no discrimination here.
And you're saying that based on the fact that you were in good faith applying a federal rule, right?
The rule in the Maine Care Benefits Manual, right, and the reimbursement rate that was approved by the legislature in the rule, yes.
And just to go over again, what is the situation now? What is the reimbursement rate for the two disabled people that are in the home?
I don't want to misspeak. I know that both parents are serving as DSPs, and they are each receiving the per diem rate. I'm assuming it's still 156. Complainants counsel may be able to answer that better than I can at this point. I know that rates have changed.
Yeah, I don't care about the amount, but there are now two DSPs?
Yes, they're each serving
Both
as
parents?
a DSP. Pursuant to the Superior Court's order, yes, they've both been approved to be DSPs in the home. The department is reimbursing the administrative oversight agency for the two DSPs, yes, per diem.
Well, that's why I'm saying it sounds like it's moot, because that's the relief that they wanted was 2 separate DSPs.
I think on the complainants council, maybe answer that as to what they're looking for at this point.
Thank you.
If that's okay.
Any other commissioner questions for Attorney Morrell at this time? Seeing none, you'll have about 4 minutes when you come back. Attorney O'Meara, I assume you will have 4.5 minutes worth of things to say.
We will see. Let me address the mootness first for you, Commissioner David. The case is not moot because there was a long period of time where there was discrimination at play here when the young men did not receive their full services. What you need to keep in mind, and I think it was murky in the last presentation, each of them needs full day one-on-one services. That's what they're each entitled to. The fact that the department would let them live in the same home does not give each of them full day one-on-one services. It gives them shared provider, one person helping both of them. That's insufficient. And basically what the act says is you can't have unequal services because of association with someone with a disability. That's what's happening here. So the case is not moot. Each needs one-on-one services. And yes, this was an error in the interpretation of the rules. By the way, it's not a federal rule. This is a state Medicaid benefit manual rule. So it's a state rule. And the fact that it was an error and that the Superior Court has corrected it doesn't answer the question that the commission's responsible for. Was the application of this rule by the department discriminatory for many years against both of these young men? The answer is yes. And the department says that there was no dictating of who the boys lived with when they were receiving the service. But in fact, it did dictate who they could live with, because if they wanted their full service, they had to live separately. That's how the rule worked, as interpreted by DHHS. If they chose to live separately, no problem. You could have all the services that you're entitled to. If you chose to live together, no, you get half. You get to share the provider. That's the discrimination. If this happened in any other setting where somebody said, you're entitled to a full government benefit, but not if you choose to live with this person who's in a protected class. If you do that, we're going to cut it in half. You would easily find discrimination, reasonable grounds in those circumstances. And that's exactly the situation we have here. Happy to take questions.
Okay, so I will piggyback on Ed's question, Commissioner David's question. What are you looking for? Are you looking that the entire rule is changed, it's discriminatory, or are you talking specifically about the mechanics?
We're trying to say that the rule as it was interpreted for many years was discriminatory, and it should not be interpreted that way, not only because it's unreasonable, as the Superior Court found, and also because it violates the Human Rights Act. There was just 2 grounds for why this rule never should have been interpreted the way it was. The Superior Court only addressed one of them.
I think I know the answer that you're going to give, but what you're saying is that it was an erroneous legal interpretation of the Medicare rule, a state promulgated rule, and that the department couldn't rely on that interpretation to provide the services and the payment for those services that it chose.
That's correct. It was an unreasonable interpretation, and it was a discriminatory interpretation, is what we're asking you to say as well. Because it forced them to live apart from another person with disabilities to get their full services.
Thank you.
Commissioner David?
Counsel, would you speak to the you object to the finding of no reasonable grounds for retaliation, right? You think there was retaliation?
There was retaliation. We're not pressing that issue here because the question is, here, is there associational discrimination? The McKennas have pressed the same issue for the last several years. The retaliation that they experienced was because they pressed this issue. Obviously, they received various rulings and due process issues from the department for many years. But for the purpose of reasonable grounds today, we're simply asking for a ruling on the issue that they raised, the associational discrimination.
Okay, so you're not pressing the retaliation claim.
No, no need.
Okay, thank you.
Other questions from commissioners for complainants counsel? Being none, thank you.
Thank you.
None, Ms. Morrell, you have about 4 minutes.
Just briefly again, the department does disagree that at the time, the brothers were receiving half services or not full services. Under the department's interpretation, they should not have been receiving half services. They should have been receiving full services by the one DSP. And they were not forced to live apart. They were still living together at the time. There are also natural supports available in every situation. That natural supports in the home that can be contributed as well. So that's the only additional point I wanted to make. Yes.
What do you mean by that? Yeah,
Just people living in the home, helping them with the care.
okay, that's kind of, okay.
The other commissioner questions for Attorney Morrell?
Just to clarify, you just want to make sure I understood it. You said that they were receiving full services from one DSP.
They should, that's
The
the
two were
agreement,
giving-
that's the agreement that the DSP makes with the administrative oversight agency when a DSP takes on this role. I also just want to say, the department is by no means trying to minimize the struggles of this family and, you know, the issues they're facing. I don't want to come across as, you know, cavalier. We're by no means trying to minimize any of this, but the department has to administer its programs even-handedly so that there are enough benefits for everyone to go around. Thank you.
Next, we would hear from the investigator, Alex.
Hi, good morning, everyone, commissioners. My name is Alex Brindley. I was the investigator assigned to this case. Now, first, I want to apologize for any error in, not including the associational discrimination claim. However, even if I had added it, my analysis and the outcome would have been exactly the same. I think the only thing that I would have changed, if we look to my report on page 5, subsection 5, it talks about the prima facie case. I think in the last sentence, all I would change is that complainants claim that they were discriminated against based on the degree. So what I would change there is I would say that the complainants alleged that they were discriminated based on their association with individuals who require one-on-one care, meaning that they both require high level of around-the-clock care. So I think really the association claim really, in my eyes, depended on the level of care that both of the complainants required. So because Jared was receiving, as a side note, Jared was always receiving his requested care. He was receiving shared living services throughout the entirety of this case. It was really more Gavin. And at that time, Gavin was living with Jared. Jared was still receiving care, even though Gavin was living in the house with them. So that really led into my analysis as well. For me, it really seems that it was the level of care needed. And Attorney Morrell talked briefly about how the way that the statute was originally interpreted was because they didn't want to turn a shared living arrangement into perhaps a group home. And that's why I have the level of care analysis in my report, because it seemed to me that the crux was if one individual was receiving like around the clock 24/7 care, having another individual also receiving 24/7 around the clock care would lead to that group home scenario based on their original interpretation, and it wasn't dependent on the disability status, more the level of care. I'm open to any questions. This case was very difficult. I talked about this with my coworkers and council many times, so please feel free to ask any questions and I will try my best to answer them.
Commissioner, questions for the investigator?
Uh,
Sorry, Commissioner, yes.
Would the analysis, Alex, be different if they weren't brothers? If it was somehow the associational discrimination claim suggests to me that it's, not a family member that's associating, and that would be discriminatory. Would it make any difference?
No, it wouldn't make any difference if they weren't brothers. They would still be two individuals requiring around the clock care, and based on the original interpretation, that might potentially lead into the status of group home care. Based on the new interpretation, however, that wouldn't be the same, and they would both receive individual shared living services. But yeah, I don't think that would change whether or not they were brothers.
Okay. And the current situation is that each parent is designated as a provider for one child?
Correct.
Okay. So I'm not sure what else they could ask for, right? They're not. They're just asking for a determination that it was discriminatory before that ruling. Is that what you understand?
Yes. That the interpretation of the statute or the Medicare rule was discriminatory. That was my understanding.
And there was an appeal. Do I recall? I read this a couple of days ago. Was there an appeal procedure under the rule or in the department?
Mm-hmm. They definitely appealed the process and then took it to court, where the interpretation of the word arrangement changed the DHHS's interpretation of how they apply the statute.
Can I interrupt everyone? It's been 10 years and I've never done this. The arguments today and reviewing the record, which I'm doing frantically while this argument has been occurring, I can no longer say that this is a legally defensible report. I don't know what the outcome could be, but I'm going to admit that I didn't think about this as an associational claim. There's one line at the end of the complaint, and reading the record, it appeared to be an individual discrimination claim. But if that's not what it was intended as, I can tell you that's not how I thought about it. And what I would suggest is that we send it back to be investigated as such. And I apologize to the commission and to the parties, but I just can't sit here and let a vote happen without admitting that I think I messed this up. And Alex did rely on me, and I did not see the argument for what it was supposed to be. I do not think that is entirely my fault. I think it certainly could have been clearer. But having reached the point where we are at today, I think we need to send this back. And now I'll go sit in the corner.
Would it be appropriate to act on the two requests separately? I mean, they're not pressing the second one. We could dispose of that and then send the first one back for reinvestigation, or should it stay together?
You mean the retaliation claim? I don't think it does anything. You know what it does? It confuses court deadlines. So let's not do.
Procedurally.
Never mind. I agree.
So before the commissioners decide what, if anything, to do, let me say there is not a motion pending. Do you have any questions for council before you determine what commissioners want to do next?
And please don't let them be, what the heck is wrong with you? I'm embarrassed enough.
Is there an option? I hear what you're saying, and I understand. I would not want to run afoul of highly esteemed official counsel. However, could we not opt to vote on what's been presented today? I mean, for myself personally, I feel like the issue is pretty clear. Don't think we need to waste commission resources with follow-up with we're all feeling that we have enough evidence to vote on the association. Really is a question.
If you all want to vote, go ahead. I have said what I needed to say.
So commissioners, it's before you, you've heard from the parties and the investigator and your attorney, at least on the initial point of the report. And it is for you to determine how you want to proceed at this point, whether to vote on the recommendations before you or return the case for more investigation.
So that's a little tricky because there are no recommendations before us with respect to the associational claim. Right, so we
Correct.
need to make a motion for some different funding.
Suggested what I had
So
suggested.
procedurally, can we not just vote on that, or do we actually
Procedurally-
need a
Hang
report
on, let me
to?
look at what's right.
Yeah,
Procedurally, you are.
It just says discriminated on the basis of disability. It does not spell out a particular theory. If you would like to spell one out in your motion, say that there were reasonable grounds based on association and then no reasonable grounds individually. I think that still works with the finding that was recommended. I think it's still technically before you.
Commissioner Walker?
Procedurally, are we allowed to have discussion before we have any motion?
No, you should probably move, but I'm not allowed to discuss with you once there's a motion pending.
Okay.
So that's why I interrupted when I did.
And we're just discussing procedure now. So if someone has, oh, I'm sorry, Commissioner David, thank you, Chelsea.
Yeah, I think I'm comfortable with remanding it for further investigation. And I'm not sure that Tom is. I sense that you think you have enough there, but I am still concerned about a better analysis of association. And exactly what that means for family members and that kind of thing. So I'd be comfortable with remanding it if there's support for that. I won't make the motion yet until I hear from you guys.
Commissioner Walker?
I agree with that. I think I sense that you were looking for something different, but I'd like to see more legal analysis of the association path.
Commissioner Douglas, Commissioner O'Brien, do you have any procedural comments you want to make at this point?
I'll stand on my previous comments.
Okay, so at this point, we need one commissioner to make a motion about how to go ahead procedurally. Commissioner David?
I move that we remand the case to the investigator for reconsideration and analysis.
Is there a second?
Second.
So the motion is to return the case to investigation. Is there any discussion? Commissioner
Quite
O'Brien?
a good question. So this means, for this individual case, this really, I don't want to say means nothing. That's not what I mean. But there's no, I mean, it's set now. They're getting paid what they wanted in the first place. But I just want to make sure that if this goes back, this doesn't continue having a negative effect on these particular complainants. Is that clear? No.
I understand the point you're making.
Yeah, okay, thank you. And I don't know who to ask.
This isn't necessarily a question and answer
I know.
time. This is a discussion among commissioners time.
Okay.
Is there any other discussion among commissioners?
Well, Julie, I don't think it would, but there's nobody else to ask, because I asked them if they were set and happy with the result. Now there's 2 full-time care providers that are being authorized by the department. So I don't think it has an adverse effect, except for continuation of stress and litigation, but I don't think it has an adverse effect.
Okay.
I mean, in terms of additional discussion, I would just state, sort of, in addition to my previous comments, I just don't know what additional we're going to learn from an additional investigation that's not already in this report. Because the associational analysis is not present, does not mean that the facts underlying same are not there. And so I just don't know what additional we're going to learn. And I would just vote on it today.
Mr. Walker?
So I would agree with the first half of what you just said. I don't think the facts are going to change. I just want more legal analysis. I'm struggling with some sort of, rightfully relying on legal advice by the department to provide those services the way they interpreted the rule. They have since been told that that interpretation is incorrect. And it wasn't necessarily reviewed from the perspective of associational or disabilities. So, since I'm confused by the law, as a lawyer, frequently happens, I'd like to hear more in-depth analysis on the law itself.
Any other discussion among commissioners on the motion to return the case to investigation? Seeing none, if you are in agreement with the motion to return the case to investigation, we will vote yes. Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Commissioner, you're sure about yes?
Yes.
Okay, Commissioner Walker?
Yes.
Commissioner Douglas?
No.
So with that, the commission has voted to return the case to investigation, and we apologize for the delay to the parties. We want to get it right. Well, we want to make sure we're giving all the issues their proper analysis. So the commission will be in touch with parties and council shortly about how we will proceed, and thank you very much for participating today. And with that, we will move on to the third case. E220017. I'm sure I'm going to pronounce this wrong. Michael Kazrak versus Tegna Inc. And I don't know if there was someone here. Are you Mr. Kazrak?
I am.
Did I butcher your name?
Yes.
Very sorry.
Never happened before.
And you tell me how to pronounce it properly.
Kazrak.
Kazrak. Well, that actually makes a lot more sense. And let's make sure that we have, is Miss Grassenbacher here? Again, apologies.
It's Grossenbacher, and yes, I'm here on the Zoom link.
So I have gotten both of your names wrong, so you're even. So Mr. Kasperzak, I also did it wrong there. So you have 10 minutes.
Thank you. I'll not use it. I'll make it brief and hopefully less legalese than those before me. I thank Ms. Morse for she did a great job on the interview and the fact-finding mission, I thought, but she omitted some key details, which I'm kind of curious about. I'm just a person. I worked 26 years at Tegna in Bangor, not Standish, by the way. That's on the docket, Standish. I don't understand that. I'm from Bangor. I work at WLBZ TV for 26 years. And Ms. Morse's findings, she also said that I kind of rose through the ranks to do what I did. No, I survived. I started out as a director of the news. We lost the news. Once we were taken over by Tegna, this massive corporation, of course, they start downsizing, and Bangor is now just a remnant of what it once was. That's part of the business. I get it. My wife was in that annexing and she lost her job. That's fine. That's business. So I went for 26 years, and during the pandemic, I was considered an essential employee, and I was one of the 3 people in the building. I made commercials. That's what I survived, because I could do anything. I could shoot, I can edit, I do voiceover work. So I survived all the cuts and ended up making commercials for a living, and that's what I did. So from there, during the pandemic, I was one of the only people in the building because of my technical abilities. and I was considered an essential worker. Then the mandates came and I asked for religious accommodation because they said that's the only way that I could go. So I asked for one, I was denied one. I asked for an appeal, I was denied an appeal. The reason why I was denied an accommodation was because they found a legal loophole and they said that it was going to be too costly because my job description was a certain way. Also left out of the support was that I did this job for years prior to the pandemic and during the pandemic. But prior to the pandemic, I did it with relatively little interaction with other people, and I did it fine. So what it seems to come down to is that Tegna just wanted to get rid of me, and they didn't want to give me an accommodation. I'm sure Mrs. Grossenbacher will give you reasons why they did that, and maybe they're true. I don't know. I can't read their heart or their mind as to why they did this. I just want to know why, after 26 years, I was considered persona non grata and told you're no longer needed here. I suppose if I was an awesome employee, they would have bent over backwards and found a way to grant me that accommodation. But should they be able to use that as a way to get rid of people? Because if they're going to try to prove that my job description was thus, and there was no way that I could work around that, I've done it. I did it for years. So that's fiction. But again, they'll just rely on the fact that that's what they asked my supervisors, and that's the answer they gave me because that's the answer they saw. That's what I was doing. That's how I performed the job. I did go out and I interacted with other people because I chose to do it, but I did it for years prior to that with no problem. And that will be the end of my statement. I'll bankroll my time in case I hear something that I have to complain about.
Well, now let's see if commissioners have any
All
questions
right.
for you. Oh, and they do, Commissioner O'Brien.
Thank you. Okay, so this is a religious discrimination case. You're alleging that, but and I
Can I be clear on that?
Yeah.
I don't know. I'm gonna not pretend like I know and can read their hearts and minds. All I'm asking is, why was it denied? So if it is that, Mrs. Grothenbacher has brought up religious things or tried to make me look like I don't know the Ten Commandments or something. I don't know why she would bother. I don't know why, even if I'm to understand Title VII works for atheists too. It has to, or it's useless. Am I correct in that assumption?
Well,
This is what I'm trying to find out.
Okay, so this does not work. You need to let
Okay.
her ask you a question and an answer.
okay, so I mean, that is what we're trying to find, because we need, in order to be discrimination, against the Human Rights Act, then we need to have some reason for the discrimination for a protected class. And this has been filed under the religious, they're alleging that they failed to provide you with a religious accommodation.
That is a fact.
Okay.
So whether that.
So then my question is, and I really should probably know this, but there were quotes assigned to you that that put you at odds with at least 3 of the 10 commandments, 5, 1, and 4. What can you just tell me what those are? I mean, I should know what 5, 4, and 1 is.
5, according to Catholic tradition, is thou shalt not murder.
Okay.
1 is that that God is God. It's
Okay.
to honor God. Yeah.
Yeah.
Put no other God before me.
Right. Okay.
What was the other one?
4.
4. I don't know. I can't remember
Okay.
what that was at this time.
Okay.
It was kind of a glib sort of, that was what I said at the beginning, and I was I had to actually look up those commandments and say, these are the ones that I thought of. And I was being glib at the time because it was my understanding that I really never had to give any reason as to the religious practices that it was offending, other than it's between me and my God. And really, that should be good enough.
Okay,
Actually, my personal beliefs.
thank you.
Any other commissioner questions for complainant?
I guess I'm just wondering, is there anything else? Right, so you understood Commissioner O'Brien's question, right? She wanted to know, you're here because you have religious discrimination, right? I mean, so.
Could you just let her?
Yeah, just bear with me, sir. So, Commissioner O'Brien's question goes to the report here where, you're being asked basically, what's the basis for your religious belief that you cannot be vaccinated? And you said in the 10 Commandments, right? And I'm just wondering, is there anything else in your religion that mandates that you cannot be vaccinated?
There, again, mandates that I can't be vaccinated? No.
Okay. I mean, is there anything else about your religion that you want to tell us today? Hold on. With respect to this, your decision to not be vaccinated.
Yeah, it's against my sincerely personal held beliefs.
Okay, thank you.
Any other commissioner questions for complainant? Seeing none, thank you. We'll have about 6 minutes left. And now we are at Ms. Rosenbacher.
Hello, I'm Carla Grossenbacher. I represent Tegna Inc. as licensee of WLBZ. We would ask the commission to accept the no reasonable grounds finding in the investigator's report. As I'm sure you all know, in order to take issue with the report, complainant needs to point to factual errors or facts left out of the report or issues and questions related to an interpretation of law. It seems pretty clear that complainant simply disagrees with the outcome of the report, and we believe he hasn't met the standard for seeking review of the report. In his email in which he sought to appeal the findings in the report, he pointed to 2 things. One, that the report didn't recognize that he had, for some time, as he just told you in the room, been performing his duties without interacting with individuals. But the report did address this and clearly stated that during the pandemic for a period of time, and yes, as we all know, it was a long period of time that covered more than 1 year, the station excused individuals like complainant from performing in-person duties and allowed them to do them as best they could in isolation. Many employers did that. But a time came when the station wanted to get back to the normal way that marketing producers like complainant shoot commercials, and that's in-person interacting with people. Complainant is not the only marketing producer at WLBZ. They all shoot commercials in person. That's how it's done. And that's how expected to be done outside the pandemic. The other issue that Mr. Kasperzak spoke to in his appeal was that the station carried its burden of showing that it conducted an interactive discussion with him. And the report, to the contrary, found that the station did, in fact, show that it had engaged in interactive discussion. And an HR business professional interviewed Mr. Kasperzak regarding his request for accommodation. She also spoke to his supervisor about its job duties. And the station ultimately determined that it posed more than a de minimis burden on the station to allow Mr. Kasperzak to conduct his commercial shoots in person with clients and coworkers while unvaccinated in November 2021 when this decision was made. And that's all I have to say. I'm happy to answer any questions that anyone has for me.
Thank you. Commissioner questions for Respondents Council? I am not seeing any. You'll have about 7 minutes left when we get back to you. Mr. Kasperzak, you have 6 minutes if you want to use them.
Again, they did mention that I worked during the pandemic, but again, they failed to mention for years, a number of years, 5, 6, I don't know. I didn't keep track mentally. I worked alone at night. That's a big difference than just during the pandemic, because then we all worked different during the pandemic. But I did this job. I used to edit alone at night. I didn't have any interaction with anybody, including clients. That was handled by sales. I didn't interact with other people. I sent a photographer to get what I wanted. I could do that through emails, telephone calls. Sometimes I did it in person, but I did it for years. And that was left out of the report, and I don't know why. Again, I'm asking why that was left out of the report. I made that clear that my job evolved into working with the public because I chose to. We had other people, other producers that chose to work by themselves. They weren't reprimanded for not doing their job the way they're supposed to. They were fine. That was pre-pandemic. They chose to work alone. And nobody sat there and punished them and said, no, as long as the commercials got done, everybody was happy. So now we're being told that this was our job description, or this is the way it's done, and we want to get back to doing it this way. It was that way because I made it that way for myself. In Portland, they've always done it that way. As far as I know, I'm sure that there are people, I didn't talk to each individual producer and find out how they make commercials. But I made commercials on my own by myself. Again, pre-pandemic, during the pandemic.
Thank you. Were you finished?
I'm finished.
Okay.
Any questions?
Commissioner questions for Mr. Kasperzak?
Just so we're clear, so what you're saying is that you went through the whole process of making a commercial by yourself prior to the pandemic?
Yes.
And at no point during this process you had to interact with anybody else? True?
True, yes.
Okay. I just want to understand.
All right.
Any other commissioner questions for Mr. Kasperzak? Seeing none. Attorney Grossenbacher, you have 7 minutes left.
Thank you. So Mr. Kasperzak did shoot commercials in person. If we look at his March 16, 2023 submission to the investigator at the close of evidence, he refers several times to going in person on commercial shoots for his own commercials and with the other marketing producers for their commercials, and that he interacts with them very often in person. We don't dispute that there are aspects that he can do by himself, like editing. Editing you do in front of, a computer, but the actual shooting of the commercials is done live with the clients. That is how the job is done. And Mr. Kasperzak just told you that if he ever did that, he did that because he wanted to do it, not because it was required of him. We would submit that he never once refused to do it, so perhaps he never pushed it to determine that it was a requirement. But it was and is a requirement of the job to shoot commercials in person. It's what the other two people in the position do as well.
Thank you. Commissioner questions for Respondents Council?
So the complainant just told us that at some point prior to the pandemic, he shot commercials all on his own without interacting with anyone. And I just wanted to give you a chance to respond to that testimony.
We don't think that's true. How could he shoot a commercial involving live actors by himself? He has to interact with others. And again, he admits as much in that March 16th email, which of course is in the file and the investigator saw, that he would ride in vehicles with the other marketing producers, that he would go on shoots in person on his own to see clients, and also do this with other marketing producers because, as he states in the email, he was good at drawing out individuals and helping get a good commercial shoot. So I don't know what he's referring to. Maybe he's referring to isolated incidents where he, I don't even know how that would happen, how you would shoot a commercial without interacting with other people.
Thank you.
Any other commissioner questions for respondents council? Seeing none, thank you. So commissioners, you've heard from the parties. Now we would hear from the investigator, Angela.
Hi there, this is Angela Morse. I was the investigator for this case. So here my recommendations really hung on the fact that respondent met the burden to show that granting a religious accommodation to the complainant would result in an undue burden, meaning it would impose more than a de minimis cost for the employer. So de minimis meaning insignificant or trivial. So I felt that that burden was met. Also, as far as the retaliation claim is concerned, the termination of employment was because of the refusal to be vaccinated, not because of protected activity. And I'm certainly willing to answer any questions.
Thank you, Angela. Questions for the investigator? Oh, so Commissioner David.
Yeah, a question, Angela, and maybe a question for Barbara also. Just procedurally, why are some of the recommendations presented to us as twofold? One on the discrimination and one on the retaliation, where like it was in the last case, and in this case, they're rolled into one. I'm just curious, is that because it's only when there's a whistleblower that it's a separate finding that we have to make, or what?
Barbara could probably give a better answer for that, but I felt like it was two claims so that they were each being addressed.
Yeah, I mean, to be perfectly honest with you, it's really just how the particular report gets written. Either way, you're making a decision on each of the claims. It's just a matter of whether the investigator or me later chooses to break them out.
And I did have another question. If it's in the record, or is it relevant whether or not the position was filled by another hire? Would that go to whether or not he was discriminated against or not?
Well, so I'm not sure what do you mean by that? Like, it was filled by another.
Yeah.
Did they still have the need
else
for the work to be performed?
Yeah.
Yes. Well, yeah, through the investigation, it was uncovered that they did need somebody to continue to have that work performed.
And they hired somebody to do that?
I believe
they filled the
did,
position?
Yes,
right,
I believe
you.
they did.
There's a lot of talking over each other. I think you got what you needed, Commissioner. Commissioner David, did you get the answer to your question?
Yes, that's
Okay.
it. Thank you. Yes.
Okay. Any other commissioner questions for the investigator? Thank you, Angela. So commissioners, you've heard from the parties and the investigator. At this time, we would be looking for a motion or motions.
I'll make a motion. I'll make a motion that we find that there's no reasonable grounds that to believe that there was unlawful discrimination or retaliation on the basis of religion, and the complaint should be dismissed.
There a second? Second. O'Brien. So it's been moved and seconded. Is there any discussion?
Yes, he indicates that there's nothing, that it's a personal decision on his part. The required standard is that he show that there's a religious observance or practice, and I don't think he has come close to that by saying it's a personal decision that he didn't want to get vaccinated. And to call that religion would just be an untenable slippery slope, as we say.
We're
That's
not having discussion from you right now. The commissioners are talking. Sorry, were you finished, Commissioner David?
Yes.
Any additional discussion among commissioners? Seeing none, the motion is to find no reasonable grounds in this case. If you vote yes, you are in agreement. Commissioner David,
Yes.
Commissioner O'Brien. Yes. Commissioner Walker,
Yes.
Commissioner Douglas.
Yes.
So the findings are no reasonable grounds in this case. The commission will send parties and council a letter confirming that. We appreciate your participation today. And we're going to move on to our next case. So the next case is, Tom, actually, I sent you a text about the lunch. The lunch we're going to order, the restaurant I picked is not open tonight.
I knew that, but last
Mondays,
time I was.
I have terrible luck. So I think I found a substitute, even substitute for everyone but Tom. So if you could just look at the rest menu that I sent and pick something. One first. No, college carryout. Okay. The next case, the last case on the morning agenda is E220115 A through D. Jane Hutchinson versus Easton School Department, Laura Hunter, Aaron Ireland, and Mark Stanley. Is there anyone on the Zoom call here for Jane Hutchison? If you are here, please let us know somehow. I don't see anyone on the Zoom call whose identifying information says Jane Hutchison. So if you are here, unmute, raise your tiny electronic hand, do something. I see Mr. Trenholm here on respondent's behalf. I don't see the investigator calling her, did not see Ms. Hutchison on here either. So when a complainant who is objecting to the investigator, the recommended decision, when the person objecting is not here, typically the commission votes to adopt the recommended finding without holding any additional hearing or asking the respondent for anything. So not seeing Ms. Hutchison here. And I just asked our staff in the office to check our voicemail again to make sure that there were no messages saying someone was having trouble checking it, getting to the meeting. There aren't any. So I can only conclude at this point that Ms. Hutchison is not present. So typically, commissioners, you would vote to adopt the recommended findings. Commissioner Douglas.
So I'll move that we adopt the recommended findings here. There are no reasonable grounds to believe that respondents discriminated against complainant on the basis of age, ancestry, color, national origin, or race, and that there are no reasonable grounds to believe that respondents retaliated against complainant for engaging in WPA protected activity.
I'd second that.
So it's been moved and seconded to find no reasonable grounds on both claims. Is there any discussion among commissioners? Seeing none. If you are in agreement with the no reasonable grounds finding on both claims, you will vote yes. Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Commissioner Douglas?
Yes.
Commissioner Walker?
Yes.
So those findings are both no reasonable grounds. And that is our morning hearing agenda. Done a little sooner than we had planned, but that's okay because we can do our executive session now. Thank you, Mr. Trenholm. I think he's gone already. So several things need to happen. I need to order your lunch. And do you want to take 5 and then we'll do a motion to go into executive session?
Yeah.
Yes. I'd like to take 5. Yes.
All right, let's take 5. All right. Does anyone have the motion to go into executive session? It's on the email that I sent.
Who wants to hand it to me?
We don't have it printed out. No, I mean,
I don't.
Okay.
all right,
You want me to
if
read
I, do you have
it?
it? Go for it.
Pursuant to one MRS section 405(6)(e), I move to go into executive session to consult with our attorney regarding pending and contemplated litigation of the legal rights and duties of the commission.
Is there a second?
Second.
So it's been moved and seconded to go into executive session. Is there any discussion? Seeing none. If you agree with the motion to go into an executive session, you will vote yes. Commissioner David,
Yes.
Commissioner Bryant. Yes. Commissioner Douglas.
Yes.
Commissioner Walker.
Yes.
All right, so now we are going into executive session, which means Chelsea will stop the recording. Or no, we keep the recording going, but you're turning off. What are we doing? How do we do this again?
When someone was remote, you did a breakout room, so that way the
Yes,
participants can.
yes, hold on, let's do a breakout room, hold on, thank you. Yeah. Hold on, we're gonna add you, Barbara, in there and Ed in there, not including RHRC. All right, so for folks who are still watching online at this time, the commission is going into an executive session. You are welcome to stay in the open session, but should not be able to see or hear anything that we are doing. We will return to the large meeting when executive session is over.
The,
Okay, so we are back in open session. Can you check on the?
yeah, there's a lag.
What?
There's a lag, so it might.
Oh. Luckily for you, Kit is much better at this sort of stuff.
Do you want to adjust that camera angle to? Do you want to adjust that camera angle to go include the commissioners? The cam.
Hey, I'll be back. Chelsea will fix it.
Okay.
I got her here. We just came back into open session. We're working on it. Chelsea's here. She'll fix
Got it.
it. Okay. Yeah.
Okay, the live stream is back up.
Thank you.
Test. I just heard Ed on YouTube.
I think maybe now. Ed, can you hear us?
He was asking
Yes, I can hear you.
camera angle to be
Yes.
changed. Yes. We're working on it. There you go. Chelsea fixed it. Okay, so we're back in open session and I'm looking for a couple of motions, one related to a litigation case, actually both related to litigation cases. Anyone advise?
All right, so I move that we do not litigate the following case, PA 21-0339.
Is there a second?
Second.
So the motion is to not litigate the post-conciliation case, a case that did not, a reasonable grounds case that did not resolve in conciliation, PA 21-0339, Lehman versus Tri-County Waste. Is there any discussion? Seeing, can you pin Ed for us? Yes, thank you so much. Seeing no discussion, if you are in agreement with not litigating this case, we will vote yes. Commissioner David?
Yes.
Commissioner O'Brien? Yes. Commissioner Walker?
Yes.
Commissioner Douglas?
Yeah.
Okay, thank you. There is one other matter. We can get a motion on that. It is the matter of E20-0544, which is Randolph versus Rockland Marine. Thank you so much. That's great. We are looking for a motion to authorize Commission Council to sign the agreement, the settlement agreement, which includes public interest remedies. Commissioner O'Brien?
Can I just say so?
Yep.
So moved.
Is there a second?
Second.
Okay.
Second.
Okay. The motion is to authorize Commission Council to sign the agreement in E20-0544 on behalf of the Commission regarding public interest remedies. Is there any discussion? Seeing none. If you're in favor, you will vote yes. Commissioner David?
Yes.
Commissioner O'Brien? Yes. Commissioner Douglas?
Yes.
Commissioner Walker?
Yes.
Okay, so I think with that, thank you. I think We still have half an hour before the start of our afternoon session. Apologize for the lag. It's very difficult to anticipate exactly what will happen. So we would be at rest for this half hour. Lunch should be here in 15 minutes. The jog around the park, you can do it. I am not going to.
Neither.
So you're going to leave the connection open, right? I don't want to try to have to sign in again.
Nope, not gonna do that.
Okay, half hour. Or as soon as anybody shows up.
Someone's showing up for sure. I believe so.
Here, and nobody's actually referred to my case yet.
Yes, we will be, your case, Ms. Correa, is on the afternoon session. If you look at the agenda that we sent to you, it shows that the afternoon session starts at 11:45. Your case is the third case in the afternoon session.
Okay, thank you. Thank you for that.
Hello. Is my able to be heard? Am I doing this correctly?
Okay, so we are back for the afternoon session. Julie, would you be so kind as to read that introductory statement again for the afternoon folks?
Yep. Good afternoon. I'm Julie O'Brien, and on behalf of my fellow commissioners, welcome you to this meeting of the Maine Human Rights Commission. Before we proceed with the business of today, I'm asking each of you who may have an electronic device, cell phone, pager, etc., to ensure that they are silenced now. We have additional agendas, including the consent agenda, available in the back of the room. The consent agenda is a listing of cases in which no written arguments were made to the commission in the allotted period. The commission has voted on those cases and they will not be considered further today. The remaining cases on the agenda today are coming before the commission to determine if reasonable grounds exist to believe that unlawful discrimination has occurred. The commissioners have received and reviewed investigators' reports and any written submissions submitted within the allotted time. No new information or any written materials will be accepted today. Cases will be called in order on the accepted agenda. As I call each case, or as Amy called each case, the party who has submitted a written argument will be called to the podium to provide the most relevant argument to the case. The time is limited to 10 minutes. Time may be reserved to rebut opposing arguments, but the time limit of 10 minutes may not be exceeded. The procedural rules of the commission specify that your arguments may address only 1, relevant factual errors, 2, relevant omissions from the report of facts submitted during the investigation, or 3, relevant issues and questions concerning interpretation of the law. The commission allows parties who do not disagree with the investigator's report to rebut comments made by the opposite party. Please be advised that commissioners may ask questions. I will ask that you introduce yourself as you present.
Thank you. We would also ask anyone who presents to not use the names of third parties in our reports. We've given anyone else who's involved in a case as a witness or who's not a party a pseudonym. So we'd ask you to please use that. The first case on the afternoon agenda is H220429, Thomas Rogers versus Freeze Building Associates Limited Partnerships. I see Mr. Rogers. So, Mr. Rogers, if you could unmute yourself. We'll have 10 minutes to make a presentation. Okay?
Thank you, and good morning to the commission. I first start by reading the paper that I sent in to the commission, and I would like to start off by disputing the summary in which Cindy Batchelder was the one stealing from the homeless people.
So Mr. Rogers, that's the name of someone who's not a party. So I'm gonna ask you not to use that person's name.
Okay, I apologize.
So if you look at our report, we used a different name for that person. That doesn't, a description of them.
I apologize. In the letter that I got sent back, her name is still in there. I was unaware of her being not the representative of the case.
So like in our report, I'm not counting this as your time, like your mother is not a named party, and in our report, we call her mother instead of using her name. That's what I mean.
Okay. Cindy would be the landlord.
Yeah, and I would like you to not use her name.
Okay, okay, I apologize. I'll just call her the landlord, then I certainly apologize.
Thank you. Go ahead.
Okay, apologies. The landlord was not stealing from the homeless people, but instead was a different tenant that was not mentioned by name.
Thank you.
And also that the tenants living in the loft section next to my former bedroom window was not given the landlord the disclosed information to me, as well as the names of the squatters living within the building. I question why the ones living in the storage closet at the end of the hall on the third floor of the freezers building was not mentioned within the report. 3 neighbors on that floor experienced bed bugs, as well as the tenant in the 4th floor, 401, which was handled by the maintenance men working within the freezers building. This information was not disclosed to my mother and I. Usually bed bugs come from old houses and apartments that somebody might be living in, shelters. This was not documented and seemed to be ignored, even though police were involved. The matter of no cameras within the building besides the first floor was an issue for safety and not mentioned within the report. I also would like to dispute the fact that the tenant in 401 was not questioned by the police, was not questioned by the police if she was the one harassing me. It could also be the squatters or maybe guests that come by and start speaking with her through her floor towards the apartment below into my old bedroom. I cannot recall if she was questioned by the landlord, for she did not disclose that information toward me. I also would like to dispute other tenants' complaints towards my behavior. This was not disclosed to me in any of the documents given for this case until after the deadline set by, I can't use the name, the commission. The ones in question are from 2020 when my father was living within the apartment. These documents and accounts should not be connected with this case and are of a different matter altogether. These complaints were out of my control and should not be used against me, in my opinion. I moved in with my father and mother during February of 2017. Pertaining to the complaints made by other tenants over my disruptive behavior, I feel that these were unfair and portray me as someone who cannot control myself. My quiet enjoyment was disrupted by the neighbors around me, wanting to do so to cause wanting to purposely do so, to cause my bipolar to trigger as well as my schizophrenia. They are false and are slander against my character. I have not physically abused anyone and will not purposely conduct myself in that way. The reason behind the source of those complaints were likely the result of my frustration involving the neighbor's harassment, ending in the police getting called to investigate. I am able to return. The verdict set against me by the judge will allow me to return and visit my mother 1 year from the date signed. I may still speak with her over the phone and by text message. I may also return by police escort to retrieve my belongings, but only twice for the year. The reasonable accommodation set in place by my lawyer and the Freezes building, and the Freezes building was indeed granted with the terms of continued tenancy with continued treatment, and was indeed argued that my behavior was a direct result of my disability. I feel this agreement was forgotten and was no longer in effect from the lack of security cameras and the squatters. I also would like to dispute the matter of all complaints being addressed as much as possible. I left a complaint regarding a teenager within the apartment next to my old bedroom window who I had verbally argued with. This was left unresolved and was made to be believed that I was making this up or it did not happen, primarily due to my disability of schizophrenia. The neighbors knew that I wouldn't be believed, and wanted to continue this harassment without consequence. I was unable to record this incident. The teenager wore a green t-shirt and threatened to walk over to the other side of the building and physically assault me. I was never informed that this was addressed or investigated. The worker located over at the third floor lofts lied when questioned and informed the landlord that there were no children located there. And the landlord did not believe my complaints pertaining to the lofts. I am unaware if any security cameras are present on that floor as well. I am also aware that this cannot be proven due to the lack of jurisdiction. I would also like to dispute if the commission was given the proper jurisdiction that they would find the proof of the squatter on the third floor storeroom and a plausible case of harassment would be established and further investigated. I also would like to dispute that the fact that I was held against my will in the Northern Light Medical Center and was already in treatment for my disability by the doctors at Arcadia Hospital. I was found not to be a danger to society, and after going back to the apartment and continued my medication treatment, I was still experiencing the harassment. The squatters were harassing me through the walls and did not leave those apartments. My mother should not have been a source of information about this harassment, for she does not speak for me and is not my guardian to do so. Even though she is the head of household, she does not fully understand my medical treatments and history regarding my mental health. The landlord wanted a second opinion before freely continuing an investigation, which was difficult to produce. These incidents were only occurring during the year of 2022 and not during my full tenancy within the Freezes building. The harassment started during the beginning of 2022, and as mentioned in my previous letter, I would hear most of the harassment coming from the pantry. There is no mention of another meeting going to take place with my attendance. I feel this was possible discrimination by not respecting my words or thoughts about the harassment and dismissing it due to my disability. I also feel that my answers to the request for more information given by the commission were not fully understood and seemed untrue. My character is such that I do not lie or try and disturb other people's peace and quiet on purpose just because of my disability. I felt strongly about the information I was trying to give, and did fail in not putting references in those documents that would help support my claims. It is also very difficult, to try and prove my stay at the hospital during that time when I cannot access my documents in my former bedroom. The court orders put on me by my mother and the judge wouldn't allow me back within the apartment, but only by a police escort. I would also like to dispute the fact that the laws in Maine about mental illness, people with mental illness being held against their will by doctors or police. I am unaware I needed to provide the proof of the law and assume that the commission would research the law and connect it with my complaints. I am aware I could not provide the reference to the commission and will ask if there would be a chance to open another case about discrimination if I'm able to give the jurisdiction to do so. As mentioned in my previous letter, the tenant in apartment 401 suffers from being mentally challenged and schizophrenic. This is known to me by the means of my mother, who was told by the tenant in 401's home aid worker.
Mr. Rogers, I'm sorry to interrupt you, but that's the 10 minutes that you're allowed. So I'm sorry to cut you off, but at this point, I'm gonna ask our commissioners if they have any questions for you. Okay?
Thank you. That is fine.
Commissioners, do you have any questions at this time for Mr. Rogers? I don't see any. So Mr. Rogers, thank you. I'm going to mute you right now, and we're going to turn to, I believe that Ms. Attorney Librato might be here for the Freeze building. Okay?
Okay. All right. Thank you. Thank you, Commissioner. I apologize that I couldn't.
Oops. Sorry to cut you off. I started muting you before you were apologizing. Attorney Librato.
Good morning or good afternoon, commissioners. Yes, my name is Esther Librato. I'm counsel for the Freeze Building Associates. And the complaint in this case is that my client discriminated against Mr. Rogers by not thoroughly investigating his concerns when he raised them. The property manager, I believe it's the same individual that Mr. Rogers referred to as the landlord, she did thoroughly investigate every complaint that Mr. Rogers made. She takes all complaints received from tenants very seriously, and that's as required by the resident complaint policy, which we attached as Exhibit H to our April 17th submission. Each time the property manager received a complaint from Mr. Rogers, he did investigate it, but each time was unable to find any indication that any of the events that Mr. Rogers described had occurred. She did speak with the neighbors, that some of whom were mentioned by Mr. Rogers. In one instance, also spoke with that neighbors or the other tenant's caseworker, and to the extent that the property manager spoke with Mr. Rogers' mother, who he lived with at the time, it was in relation to events that were occurring, as he described, that were occurring in the apartment, in which she shared with him and would have been able to hear. Each time, as I mentioned, there was no basis for any of these complaints. The property manager did follow that policy in communicating with him that especially if there was any additional information that he was able to obtain in terms of the things he was complaining about, to be sure to bring it to the property manager so she could continue investigating that concern. The investigator in this case conducted a thorough investigation, and we agree with the findings there, in which she found that Mr. Rogers had not established his prima facie case of discrimination by the Freeze Building Associates. And as I described earlier, the complaints were investigated the same as any tenant complaint throughout the building. And our client, and in particular the property manager, treated him to the same and did not discriminate against him. I'll finally just mention, as has already been mentioned, that as of right now, there's a protection from abuse order in place that was initiated by Mr. Rogers' mother. And he is not permitted back on the property until April of 2024. And I believe he's already mentioned, except to obtain personal possession. And I'll save the rest of my time, but I'm happy to answer any questions.
Thank you. Any commissioner questions for Attorney Librado? Not seeing any. Thank you. Typically, we would go back to the complainant, but Mr. Rogers has used all of his time. So Attorney Librado, if you have anything to add, this would be the time to do it.
Thank you. I just would ask that the commission, in accordance with the investigator's report, find that there are no reasonable grounds to support the complaint in this case that the Freeze Building Associates discriminated against Mr. Rogers.
Thank you. So we have heard from the parties, and now we would turn to the investigator, Alex.
I took a second to unmute myself. Hello, everyone. My name is Alex Brindley. So I was not the investigator to this case. I inherited it from Jane, but I have reviewed the file in its entirety. I think in sum, we can say that while Mr. Rogers did make complaints, believing that he was harassed, the respondent investigated these complaints and found no basis for them, which led to the ultimate recommendation of no reasonable grounds. And I'm open to any questions.
Any commissioner questions for Alex? Not seeing any.
Thanks.
Thank you. So you've heard from the parties and about the investigation. At this time, we'd be looking for a motion.
I'll move that we find that there's no reasonable grounds to believe that the respondent is unlawfully discriminated against the complainant on the basis of his disability, and that the complaint should be dismissed.
Second.
Second.
So it's been moved and seconded to find no reasonable grounds to believe that respondent discriminated against Mr. Rogers on the basis of disability. Is there any discussion among commissioners?
I would just like to say, Mr. Rogers, that although the investigator, should we go with the investigator's recommendation, it doesn't mean that we don't believe you. And I personally agree that the laws in Maine of mental health are, depends on which side you're on. So I do believe you. We hear you. But I'm going to vote with the motion. Any other discussion?
And
Yep.
Yeah, I'd just like to say to Mr. Rogers also that I heard him and I read in his submission that he did not want to be labeled as an abuser. And I just want him to understand that the findings of the commission have to do with the law of discrimination and that we are not labeling him in that way. But I will also support, I made the motion, so. That's all.
Any other commissioner discussion? Seeing none. The motion is to find that there are no reasonable grounds to believe that Freeze Building Associates Limited Partnership discriminated against Thomas Rogers on the basis of disability. If you're in agreement, you will vote yes. Commissioner David.
Yes.
Commissioner O'Brien.
Yes.
Commissioner Walker.
Yes.
Commissioner Douglas.
Yes.
So the finding is that there are no reasonable grounds to believe that unlawful discrimination happened. So the commission will send Mr. Rogers and respondent and their attorney a letter confirming that finding, and it will explain what Mr. Rogers can do if he wants to continue his claim in court. We thank you for being here today. And now we're going to move on to our next case. Oh, right, I forgot I'm calling, which is, go again. You are. Yes, I forgot, yeah. Which is, the next case is H230050, Sarah Wynot versus Maine State Housing Authority. Ms. Wynot, if you are on the call, I see that there's a Sarah. If you are on the call, can you let us know that you're
Yes.
on?
Yes,
Okay.
I'm here. And I apologize. I'm on the same computer I used last time.
Okay.
It's not okay.
That's okay. That's
Okay.
okay. I just wanted to make sure we didn't miss you.
Okay, thank you.
You'll have 10 minutes to make your statement and same rules. Don't use the names of any people who aren't a party to your case. The only party to your case is you and Maine State Housing Authority. So no other individuals' names.
Okay.
Okay, so you have 10 minutes.
Okay, all right, here I go. So I'm trying to, well, I don't even know where to begin because this case is so complex, but let me just say that, you know, I requested a live-in aid accommodation through Pine Tree Legal on October 9th, 2022.
So can I?
Oh, I'm sorry. Yeah, I'm sorry. I used the, I apologize.
Okay,
I'm
that's
sorry. I'm kind of reading my notes and then it's right
know.
there in front of me. My apologies.
Yeah, go ahead.
Okay, so anyway, I did ask for an accommodation, and the situation with this is that my daughter has been my aide, and for quite a few years now, and had taken over from my son, who left the housing back in 2018. So all along, you know, there was a phone conversation that took place with Maine State Housing. I can use that. That my son was leaving the premises and that my daughter would be taking over. Because you know, if you people hopefully have all the notes, have all the exhibits in front of you that you can see, that I did send in, you know, we can refer to some exhibits. You know, doctor's notes and so on, the accommodation that I did request, but they did not let my daughter continue being my live-in aide or would not even consider it. You know, there were things that were said to me like she needs to move out, and then she can move back into the household and will have to be recertified. Just some absurd things that just craziness. My daughter has been in that household with me since on the Section 8 certificate since she was 9 years old. She is now 23. I don't know. There's just so much to say here. Yeah, you know, I'm a disabled individual. I require help, a lot of help. And you know, for them not to allow my daughter to continue what she's been doing is kind of absurd to me. You know, they can check her background and do whatever they need to do, but they want her to move out and then move back in. There is a young child involved. He's 2.5 years old. My daughter is not able to move out due to the fact that rents have quadrupled, as we all know, and we have a huge huge population of what do I want to call it? Homeless people. So my daughter and my grandson will become homeless to be able to actually have the status quo that Maine State Housing wants, which is non-family member. That's all they want, is her to become a non-family member. And it just doesn't make sense to have her leave the premises and then to be able to come back in. And there are no rules and regulations for that, because I did ask the lawyer that represents them. And she didn't have any information on that whatsoever. So if there is some information, I'd like to have that, but I guess, you know, I did request it before and nothing came. So I'm not understanding why my daughter can't continue doing what she's done for almost 5 years now. It's just, it's quite confusing to me. This is a complex case. It really is. And let's see here. If you just let me take a minute to look at my notes. There's so many of them. You know, Maine State Housing they're very contradicting, and it becomes confusing when they say you cannot have your daughter as a live-in aid. But they say a relative can be approved as a live-in aid, and it's right there in the notes. Or she needs to move out and then she can move back in. Please see Exhibit 8. And Exhibit 8 also shows, let's see. It says right here on Exhibit 8, live-in aid. A live-in aid is a person who resides with one or more elderly persons or nearly elderly persons or persons with a disability. And it says a family's request for live-in aid must be made in writing. When reliable, let's see. Oh, I'm reading the wrong part here. Live-in aid except to provide the necessary supportive services. But it says that a family member can become a live-in aid, but they did not approve Natalie. And for what reason, I don't know. Is it because, I mean, my son was my aide for many, many years. And that was done through Avesta Housing. Avesta Housing received the information that they requested from me. I'm sorry. I used it again. I'm sorry. There was another, I'll use that as another entity. I apologize. The other entity that began with this whole voucher requested some information from me, and they received that information, which was the original doctor's letter that was supposed to be passed on to Maine State Housing. So, you know, what Maine State Housing and the other entity did is beyond my knowledge, and probably should not have been my knowledge. So I'm assuming all along that I have a live-in aid because I have to have one. And it just so happened to be my son. Well, in the meantime, while my son is doing this, my daughter is also helping. And, you know, my son ended up, you know, getting married, having a girlfriend, getting married, having children, and he left the premises. So that left my daughter as taking over his position. And I guess Maine State Housing did not approve of that. Yeah, so, yeah. Okay, excuse me for a minute.
I would say that.
Yeah.
If Natalie moves out, she has no first,
Yeah.
last.
I did.
And she won't,
Yeah.
she will be homeless.
Yes.
She has a job. You have to
Yeah,
live in
I've
it.
already said that.
And
Okay.
you also will be homeless because you
Yes.
will not have sufficient.
Yes, and when I said that, you know, my daughter would have to move out and that she would be homeless, this will also leave me homeless as a disabled individual and struggling to find somebody to help me to take care of my needs that are necessarily documented by both doctors' letters.
Or find a place to live that you can afford.
Yeah, and then finding a place to live that I can afford is going to be very difficult. My rent is very, very low, and my landlord has not raised my rent and does not plan to in the future. He knows, they know what's going on with this situation, and they're very compassionate and doing everything they can to help me, but except for, of course, having a live-in aid. I don't see anything wrong with my daughter continuing doing what she's doing. She is a CNA. She has a clean record. She has no criminal history, nothing. But they denied that back in October, like I said, October 9th of 2022. The request form is there. I believe it is exhibit, I know my time is running out. Exhibit 5, request for live-in aid. That was sent, and you'll see the date on it. And you know, they said, oh, I could have a live-in aid, but it's got to be somebody other than her. I just find that absurd. You know, it's just, you know, that's going to cost the state money. It probably cost me a lot of money that I don't have. My income is extremely minimal. I'm sure that's notated on all this information. Okay. Yeah, we'll all end up homeless. It's just not, you know, I don't see any reason why the daughter cannot continue doing what she's always done. But let me say before I have to wrap this up, you know, like I said, Natalie does not have first, last, and security deposit. And, you know, having Natalie there doing what she's doing for me doesn't cost a dime. It costs me nothing. It costs the state nothing. And, oh, I'm sorry. And my daughter, also does not get any help from the state. No food stamps, no nothing. But if she has to move out, she will be seeking housing. She will be on food stamps. She will be on a lot of other things. She will be requesting that. It's, you know, the situation is it's dire. It's really dire for all three of us. My daughter, my grandson, and myself. There's been no issues until the point of the last recertification, which was last year, October 20, in 2022. It was August of 2022 that this whole process came about. When they took my rent away for 3 months, they included Natalie's income, and I lost my rent. It was devastating. So they did reinstate, but now we're going through this process. And it's just been a long, grueling process of something that can be so simplified. This having her there is not hurting anybody. You know, if you know, she's just continuing doing what she's doing for me at no cost to anybody. You know, it's a safe place. I'm safe. I just don't understand why they would deny her and you know, and like I said, I'm disabled. That's why I am and this other situation with
Ms. Wynot?
yes, I know my time's up. I'm sorry.
I'm sorry to interrupt you, but your time is up.
Yes, ma'am. Yes.
So at this point, I'm going to turn and ask commissioners if they have any questions for you.
Yes.
I see Commissioner O'Brien.
Yes, thank you.
Yes.
I'm reading something, I believe it's in the investigator's report. And as you were speaking, I was wondering if you would address this.
Yes.
The daughters strongly suggest that you needed the daughter to be named as your living aid to ensure that her income would not be counted against the household. Can you speak to that?
I absolutely no, that's not true. And I'm really sorry that they feel that way. That's no. I sought legal help in the beginning. I had a couple consultations that I had to pay for during this case because I'm going this alone without a lawyer. But this was the lawyer's you know, suggestion on the going forth with you know, the focus on, you know, man versus woman and discrimination based on disability. No, that there's no truth to that. You know, Natalie's income, oh, sorry, my daughter's income was never counted up until 2022. And nor was my son's. Never counted. He was in that household and on that voucher since 2011. And no income was ever counted by either one of them. Zachary's was, oh, sorry, my son's was never counted, and my daughter's was only counted in 2022. And her income was always given to them because they have notes on that. I have the copies of what they had sent me. And so up until that point, so that's a little confusing to me. Now, a live-in aid's income is totally it's obsolete to, you know, it doesn't get counted. So so they decided to count it in 2022. So I'm not understanding why didn't they count it in 2021, 2020, and so on, even way back in 2011. So my assumption all this time has been that my son was my live-in aid. That was granted, whether it came from the other entity or not, or it had, and then after he left, I had that phone conversation and I asked that, you know, I told them, I said, Natalie would like to take over, and her income was never counted. And first of all, my kids moved in as children. Natalie, oh, sorry, I keep saying her name. It's just habit, of course. You know, my children are my children, and as their mother, I have always had to take care of those children single-handedly. And they have always lived with me. So it's not like they just moved in. They've been on that voucher from day one. And Maine State Housing also put the grandson. I requested to have the grandson put on when he was born, and they did. They put him on too. So there's never been any issue that they could not be on a voucher or they would have to move in. You know, they just came and moved in. They've always been there.
Commissioner,
And I let them know. I also, yeah.
Ms. Wynot?
Okay, yes. Yes, ma'am. Thank you. Yep.
Are there any other commissioner questions for complainant? I'm not seeing any, so Ms. Wynot, I'm gonna mute you and we're gonna turn to Maine State Housing Authority.
Yes.
Is there someone here for Maine State Housing Authority? That's me. Okay, step on up.
Take the mask.
Yep.
Well, thanks.
You bet. Yep, go ahead, introduce yourself.
Okay. Good afternoon, commissioners. Thank you for having me. Ashley Carson. I'm the attorney for the respondent, Maine State Housing Authority. I'm just going to try and address some of the things that were raised by the complainant. So to start, I would just say that when she was talking about her son in 2011, she came into our program from another entity. And at that time, there was a request to add her son to the household as a household member, not as a live-in aid. And so that request was actually denied, and we went through an appeal process based on the son's past criminal history. There was an issue about having him admitted to the household, but he was eventually admitted as another household member. But it was very clear from that process that the son needed to live with the complainant for his own well-being, not to care for her. So that was what resulted from that. Over several occasions over the years, through like 2016 and 2018, complainant did call Maine Housing on several occasions, which is noted, asking about her son's status as a live-in aid, and she was told every single time that the son was not a live-in aid. Again, in 2018, she talked about transferring the status from her son to her daughter, who had now reached the age of 18. And she was again told that the son was not a live-in aid, the daughter was not a live-in aid, and likely would not qualify because she lived in the household. So it should be Maine Housing's program rules on live-in aid. You can't transfer the status of a live-in aid from one person to another. Each request for a live-in aid is a new request, and it has to go through a reasonable accommodation process. And complainant never went through this process until recently. So that's the 2022 request she's talking about. To address a few other things she talked about, the part about reporting household income. So that is the responsibility of the voucher holder. If the voucher holder does not report the income of a household member, then Maine Housing is not aware of that income. If that income is reported, but they're a full-time student or there's income below a certain threshold, it doesn't affect the benefit. So that might be why over those several years that income didn't affect her benefit, because it was low enough, or because they were a full-time student working, they get a credit for that. The denial of the daughter as a live-in aid is solely based on the Department of Housing and Urban Development regulation, which says that that person cannot be a live-in aid if they would not be living in the unit except to provide the necessary supportive services. So it's true that a relative can be a live-in aid, but it would normally be somebody that's not living in the household, has to move into the household in order to care for the family member. They have to meet all of the requirements under the federal regulations. Maine Housing can request a waiver of federal regulations, but we're not required to, and we don't do it if it fundamentally alters our program, which this would, because Maine Housing has received several requests like this in the past, and our records show that we've denied every single one because an existing household member doesn't qualify as a live-in aid. Her daughter and her grandchild can continue to live with her as long as they want. there was no request or requirement that they had to actually move out of the household. It's just that if her daughter obtains a job, that's going to affect her household income, which affects the benefit. So that was the discussion that I had with her when she reached out to me about the daughter moving out. And so what she asked me was whether or not there was any guidance on how long the daughter would have to move out for to then be able to move back in and be designated as a live-in aid. And of course, Maine Housing's program guidance does not address that because that's basically a way around the program rules. So what I had said to her was I offered her a scenario that, you know, if the daughter moved out, signed a lease, established a household, and then needed to move back into care for complainant, then maybe she would qualify sometime in the future. So that was what I was trying to address when I talked with her about that. I think that complainant mentioned that if her daughter was forced to move out, she would be homeless. Again, Maine Housing's not forcing the daughter to move out, but I think the fact that the daughter would be homeless if she had to move out shows that she has to live with complainants. So she doesn't meet the live-in aid requirements, which is they can't be living there except to provide the services. I think that's all I have to say. I would just ask that, you know, there's no reasonable grounds for that respondent was discriminated or that respondent discriminated against complainant based on sex or disability. These are clearly just the program guidelines and Maine Housing's practices and the HUD federal regulations that we're required to follow are why we couldn't approve the daughter as live-in aid.
Thank you. Hold on, do we have any commissioner questions for respondent? Oh, Commissioner David, sorry.
Yeah, it seems to me that we've taken a while in her presentation to get to the crux of the matter. I think is the money, if I understand it correctly. If you count the daughter's income, you say it reduces the benefit. Am I correct that the benefit you're talking about is the amount of the subsidy of the rent?
Right. So, and in this case, it reduced it to zero because the income of the daughter was so high that it reduced the subsidy to zero.
Right. So my question then is, are there any other services or financial consequences at stake other than that?
No, she can continue living as she is and receiving her voucher and her full benefit. But if the daughter obtains another job, the same thing is going to happen. So I think that's the issue, is that she doesn't want her daughter's income counted because it could reduce the benefit to zero again.
Right, right. And so that application is done yearly, is it?
Yeah, we recertify every year. So that would be when we would ask about the income. They are required to report changes in income, you know, intermittently, but we don't ask for that information except once a year.
And currently it would count, but there is not enough to affect the benefit. Is that the current status?
I think
getting the full benefit.
As far she's getting the full benefit because it was our understanding that the daughter lost her job. So the daughter has.
I got it.
Yeah.
I got it. Thank you.
Mr. Douglas?
I was just curious, you mentioned waiver. And then you said that, you know, a lot of people have come before you under these same circumstances that you've never asked for a waiver before. And I was just curious, under what circumstances would you ask for a waiver?
It might be a different situation. So if there's a federal regulation that's maybe less strict than our program rules, we could definitely waive our program under a less strict status. Or, you know, for HUD, if it's something that doesn't fundamentally alter our program, we can reach out to them and say, this is the situation, these are the circumstances, and we think it warrants waiving the program guidelines. But that doesn't mean that HUD's going to say yes. They could always say no, but we can make that request. But HUD has said that we're not required to if it's a fundamental alteration of our program.
Thank you.
Any other commissioner questions for a respondent? Seeing none, thank you. Why not has used all her time, so then we return to the investigator. Back to Alice, one last time today.
Back to me. Thank you, everyone. My name is Phil Alex Brindley. So I think I'm just going to run through my notes in this case. So this case initiated after complainant filed her 2022 annual recertification, wherein she disclosed her daughter's employment status and income. And that was during the Issues and Resolutions Conference. I discovered that that was the first time she had ever disclosed either her daughter or her son's income. So based on the recertification and the daughter's income, complainant's housing choice voucher was essentially eliminated. She could no longer receive rental assistance. And based on conversations between Ms. Wynot and the Maine State Housing Authority, complainant decided to request a reasonable accommodation for live-in aid. Specifically, she wanted her daughter to serve as an aid. Now, the Maine State Housing Authority did approve a live-in aid for complainant, but based on the federal regulations, her daughter could not be the live-in aid. So if you want to look at my report on page 2, footnote 4, it talks about what a live-in aid is. So it's a person who resides with one or more elderly persons or near elderly persons or persons with disabilities who, 1, is determined to be essential to the care and well-being of the persons, 2, is not obligated for the support of the persons, and 3, would not be living in the unit except to provide the necessary supportive services. And as was brought up previously, Ms. Wynot stated herself that her daughter, if she had to move out, would be homeless. And also I received an affidavit from the daughter wherein she stated that if her mother no longer needed her services, she likely would get married and move out. So that is another point against daughter living in the unit, except to provide necessary supportive services. She had been living there her whole life and likely would be continue to live there. I think that's actually all of my notes. So I am open to any questions. Just please let me know if I can assist in any way.
Thanks, Alex. Any commissioner questions for the investigator? Seeing none. Thanks, Alex.
Thanks.
So commissioners, you've heard from the parties and the investigator. At this time, we would be looking for a motion.
Well, I'll move to adopt recommended finding that there are no reasonable grounds to believe that the Maine State Housing Authority discriminated against the complainant on the basis of sex or disability. The complaint should be dismissed in accordance with 5 MRS 4612.
Second. So it's been moved and seconded to find that there are no reasonable grounds to believe that unlawful discrimination occurred in this case. Is there any discussion among commissioners?
I would just offer that I understand where the complainant is coming from, and I understand why she's here today, and I appreciate that. I do. I appreciate her making her case. It's just I mean, really what she's run into is a federal regulation that prohibits the arrangement that she would like.
Commissioner David?
Yeah, I agree. And if we didn't have that regulation, every adult child living in a home would, the parent would say, oh, that's my care person. It would, you have to draw a line somewhere. And the feds have done that, and it's not our job to second guess it.
Any other discussion among commissioners? Seeing none, the motion is to find there. Oh, I'm sorry.
I do.
No,
Do I can't say anything.
Sorry,
No.
Ms. Wynot.
Okay.
This is just an opportunity for commissioners to discuss the case among themselves.
Okay.
So commissioners, you've heard from, I'm sorry, there's a motion. I lost track for a second. The motion is to find no reasonable grounds to believe unlawful discrimination occurred. If you are in agreement, you will vote yes. Commissioner David?
Yes.
Commissioner O'Brien? Yes. Commissioner Douglas?
Yes.
Commissioner Walker?
Yes.
So the findings are that there are no reasonable grounds to believe unlawful discrimination occurred. The commission will send the parties, Ms. Wynot and Maine State Housing Authority, a letter confirming that, and they will outline your procedural options going forward. We thank you for participating today. We are finished that hearing, and we have one hearing left. That I forgot, that's still me. We are now ready to hear the last case, HPA 230068, Zelia Correa versus Waldo County Action Partnership Community Assistance Program. I know Ms. Correa is here, and I see Waldo County here. So Ms. Correa, same instructions to you as for everyone else. If you would unmute yourself, you will have 10 minutes, and please don't use the names of any third parties. Okay.
Thank you very much, ma'am, for clarifying that for me. I will do my best to adhere to the rules and regulations and not to mention third parties. I will try to refer as to the initial of the person or employee, landlord, or entities or programs that I'm under. I use those words to specify because it can be a little confusing with so many parties involved. I am legally disabled according to MHRA 5 MRS Title 4533-A, Part 1 and Part B. I have more than one condition, and of course, the investigative claim that I have at least one. I have actually 4. One of them pertaining to me being immune compromised. Now it says that they usually don't regard the severity of the disability, which I think they should, because some people can actually earn more of a living and more apt to be able to do that, which in my case, I'm not able to due to the fact that I'm actually immune compromised. And I need electricity for me to be able to use my medication, which is actually uses a machine for me to be able to, it's called a nebulizer, for me to be able to breathe correctly. Now I had applied with the respondents an application for me to receive assistance, which I have been doing that since my status of living in this particular residence, which I've been there for 13 years. And since my landlord had in 2019 decided to no longer include assistance for the electricity, which is actually my heat, I had to apply again, and then I was given an account for me to be able to have assistance put in there, so I could be able to withdraw and have that paid while I lived there. I applied on October 26, 2023. And I was told that on November, what was that? In November of 2022, that my application was complete. It was full because I was finally able to get a hold of one of the employees there. I forget his initial, but he actually told me that my application was complete and I should hear from them by the end of December, and I would be given my assistance. Now I waited till the end of middle of December, so I called up and I couldn't get through. Nobody would call me back. And then, of course, I kept calling and calling and calling. So we fast forward all the way to January the 25th, when I finally get a phone call from one of these parents' employees. I refer to this person as W. Now, W told me that my electricity was going to be turned off, but for me not to worry about it though, but that I should not be reporting people. Now, I know she wasn't referring to herself because she was not, the respondents were not the entities that I had ever reported on anything. I had reported my landlord. Now, I know for a fact that my landlord is interfering with at least 3 different of my applications, and I can prove this, provided once I get to court proceedings going. And I'm doing this by myself because I'm low income and I cannot find an attorney that's going to do pro bono. They keep saying they're all too busy or they can't take the case right now, but none of them say that I don't have a case. I received after speaking on to the W on January 25th, 2023, I was given the assistance of $605 after. Now, this was after I had reported this incident to the 3 program entities that I'm under, because they're the ones that provide the roof over my head and all these programs that I have to be under in order to maintain my life. And of course, for me to be able to have a roof over my head. And especially heat during the most winter coldest months, which happen to be January and February, which is what we were talking about here. And I had already received a notice that my electricity was going to be turned off. And she was telling me that it was going to be. And that she didn't state I wasn't going to get assistance, but she said, your electricity will be turned off. I mean, how clear can you be? And of course, she was referring to me not reporting people, and now she wasn't referring to herself as a respondent. So I know she was referring to only one person that I've ever reported, which was my landlord. How she got this information, I don't know. Either she heard it from someone or had communication with him or communication with someone else or heard conversations or heard it from someone else. I don't know. I wasn't there. But after I reported this, it reported the incident to the three entities is when I received the $605. And then I received a letter from, as part of that entity that I'm on the program under, received a letter stating that I was going to get the $605, but the time period to be used then would be 2 years, which in other words, that's what I'm going to get. Because previously I was getting 3 times that amount for 1 year. So how can I not be able to go to get a job and be able to maintain the funding to be able to pay the bills, which happens to be electricity and heat on the coldest months? And of course, if I catch a cold so much as even a sore throat, it moves right into my lungs, and I'm not just sick for a couple of weeks. I'm sick for months, fighting lung infections and everything else. That's part of my immunity, and why that's why I'm immune compromised, because of the way my medical condition is and how it pertains to me particularly. And this is something my mother has, my grandmother's had, and I have. I was also born premature. And I'm on a lot of medications to breathe. And I need electricity to use my nebulizer, because that's 3 medications plus the nebulizer that I have to use. Now, I filed with the commission on February the 22nd, 2023. Now, Inspector Moore stated that the response stated that that applicants can request a fair administrative hearing or a less formal review if they believe that their applications were not acted upon with reasonable appropriateness. Now, the city claims that the complainant did not elect to pursue either one of those options. I wasn't given one. You want to know why? Because they never called me back. I kept calling in December. I called in January, all the way until February, until I finally filed. That's when I kept calling back. And I was like, hey, call me back. I need to hear from you guys. I didn't hear a single word from them except for that one phone call from that W stating that my electricity. And then, of course, I also heard then following, before I even filed, I heard from her boss stating that I need to refer for any further assistance over to the other electricity provider, which they're not the ones that I applied application for. Now, according to the regulations of the MRA, since I was applying for full benefits, and those employees are not to actually interfere with my applications, they're not to do that, and I applied for full benefits, I'm to be given full benefits. The $605 was not full benefits. That wasn't even a third of what I would normally receive. Okay, a third. How am I supposed to keep the electricity on and pay for the full winter months when I can't even go out and earn an income enough to supply me with that? If I'm in contact with an office building and I'm there 24/7 on the job, I'm going to die. I'm trying to preserve my life as long as I possibly can, because I've had this my whole life. I know me better than anyone else. My doctors know this. My landlord has received letters. The respondents have received letters that I've provided, even with the commission, that provided that I could not be near people without them wearing masks for a reason. Okay, that's the reason why, because I'm immune compromised, especially since COVID hit. And this epidemic is what scares me even further, to the point where I can't even describe, because that is so much as even a sore throat moves into my lungs, and that's deadly to me. Imagine what COVID can do. Imagine what a cold can do. Imagine what the flu can do to me. Okay, and the investigator is stating that I needed to provide the prima facie, which I do believe I did, but because the respondents, after they were more aware of my complaint with the commission and the other 3 entities, when they started intervening, is when the respondents started supplying what I needed, and they did it in increments. Okay, and by the time the full investigation of this was actually underway and almost completed, to the Zoom meeting of where we were going to be doing a conciliation type of thing. Whereas when the inspector was saying, well, this needs to go away. Well, she's not supposed to be saying that because now she's denying me my rights to be heard, to represent this case in front of the committee of what exactly happened. And just because they later on started supplying what I needed does not mean I was being denied those benefits, which clearly that letter from what that was provided from that entity that is actually a program I'm under, which they provided that letter saying this is how much you're getting, the $605 for 2 years. That's not what they're supposed to be doing. How am I supposed to keep a roof over my head and do that when I'm being threatened? And yes, that is a threat to my life and my well-being by not me having electricity and heat, where again, I feel like I'm being threatened and my welfare is harm is being going to be caused to me because of my condition of where I'm at. And I shouldn't have to feel like I'm being threatened on a regular basis every time I apply or when I apply with this entity or the other entities or anyone else. That's not what's supposed to be happening. I'm a citizen of America. I'm protected under these laws. I'm clearly disabled. I am clearly for a protected class. I applied for full benefits. It wasn't partial. Now they're giving me not even a third of it. So what am I supposed to do?
So Ms. Correa? Ms. Correa?
Everything. Thank you so much, ma'am.
Yes, thank you. That was your time. Thanks for wrapping up. Any commissioner questions for Ms. Correa? I'm not seeing any. Thank you. I'm going to mute you while we turn to Waldo County CAP. I see someone has turned on their screen. Can you let me know your name?
Yes, thank you for having me. My name is Donna Kelly. I'm the president and CEO here at Waldo Community Action Partners.
Okay, so you have 10 minutes and I will remind you, like everyone else, not to use the names of any third parties.
Yes, thank you. Thank you for having me. Waldo Community Action Partners appreciates the ability for any individual to avail themselves of these rights. We are responding relative to some concerns that the complainant had. We do recognize that the complainant had some concerns about the length of timeliness of her application, which we agree with. We are obligated and bound to do certifications of our applications by a time stamp. We have been certifying and providing HEAP assistance to the complainant for many, many years, as she's reported. We are designed to provide services for HEAP assistance for those households that are vulnerable in our community and low income, of which the complainant is a priority applicant, which means she gets a pre-scheduled appointment every year for her application. She did complete her application over the phone with our staff on October 26th of 2022. She was fairly prompt in returning back her paperwork for the continuance of that application around or on November 11th. However, that is a completed package of information. It does not mean it is a certified application. Unfortunately, over the last 2 years, we've seen a drastic increase in applications. So we were somewhat slower in processing time-stamped dates of applications. So if her application was completed with all paperwork received on November 9th, we might have still been processing and certifying applications for October. So it did take us longer to process applications. The complainant has received all of her benefit, including regular heat benefit, supplemental benefit, and an emergency heating assistance application benefit, which actually prompted her application to move ahead of the date stamped application. What gets confusing for our applicants is that when they start getting CMP shutoffs, which does happen in the winter, even though CMP cannot turn off their electricity, it causes anxiety and concern for our households. She did receive them, as a number of other applicants received this year because of high volume. What that does is moves their regular application ahead of the time that we're certifying. So it kicks out certifications longer because we have to prompt the processing of emergency applications first. This was happening for many, many applicants. when Zelia made a complaint, I asked the director to look into the application and the complaint. We were not yet certifying the date of her application at the time. However, during that review, we did find that she did provide a shut-off notice, which moved her application into emergency application processing, which jumps her ahead of the certification timestamp. So it did take longer. We've received over 2,300 applications with over, I think it was over 700 new applicants this year. We had over a 40% emergency assistance application requirement with shutoffs, which prompted a delay in certification. But the complainant did receive at the end of January, once she received her certification of ESIP, emergency application, her regular benefit was paid of 605, her supplemental benefit was paid of 605, and in her emergency benefit was paid of 605. She does allude that we have had conversations with a third party in her housing, which we do not do. We have no need to coordinate with any of her landlords or property managers. And I did investigate that, as did our HR, as did our program director. We've had no communication with a property manager. We do validate that in her application that she is in subsidized housing, but that is the only thing that we do primarily with Maine Housing. But I do know that that was one of her concerns. So we did take longer to process her application, but in accordance with Maine Housing's rules, once she received a shut-off notice, it prompted her application to be moved ahead. It did take time though this year.
Thank you. Is that the end of your presentation?
Yes, sorry, thank you.
That's okay. Any commissioner questions for Ms. Kelly? Not seeing any. Thank you, Ms. Kelly. Ms. Correa has used up her time, so then we would turn to the investigator. One last Angela case.
Hi there, this is Angela again. I was the investigator assigned to this case. I found that through my investigation that complainant did receive the full benefits to which she was entitled, that her application was not only evaluated and processed in a diligent and timely manner, but her application was actually prioritized because of that shut-off notice that she received, and because she is disabled. So I did not find that there were reasonable grounds to believe that she was the complainant was discriminated against because of her disability or the receipt of public assistance, or that her housing was interfered with. And I'm here for questions.
Thank you. Any questions for the investigator from commissioners? Commissioner questions for the investigator? Seeing none. Thank you, Angela. So commissioners, you've heard from the parties and the investigator. At this time, we will be looking for a motion or motions. Mr. Walker?
I would move that there are no reasonable grounds to believe that Waldo County Action Partnership discriminated against complainant on the basis of disability or receipt of public assistance. And also there are no reasonable grounds to believe that Waldo County Action Partnership interfered with her right to housing through disability discrimination in violation of the MHRA, and that the complaint should be dismissed.
There's a second. Commissioner O'Brien. So it's been moved and seconded to find no reasonable grounds on both discrimination and interference. Is there any discussion among commissioners? Seeing none. So the motion is to find no reasonable grounds to believe unlawful disability discrimination or receipt of public assistance discrimination, and no reasonable grounds to believe that there's interference with the right to housing free of discrimination. If you're in agreement, you will vote yes. Commissioner David.
Yes.
Commissioner O'Brien.
Yes.
Commissioner Walker.
Yes.
Commissioner Douglas.
Yes.
So the finding on both claims is no reasonable grounds, which completes our hearing of this case and in fact, all of our cases for the day. The commission will send the parties and attorneys, will send the parties confirmation of this finding in writing, which will include information on your procedural options. We thank you for participating today, and that concludes our, Mr. David, you have a tiny hand raised.
Yeah. Well, just before we adjourn, I just want to say to you guys, I want to offer you my apologies for being late this morning. It's not that I forgot. I'm using Zoom every day. I thought I had this fully in hand. I've learned how to use the iPod. I had all the cases. Occasionally, when I try to join a meeting, my router tells it that whoever cares, like Zoom, that I'm in Canada, which I am. And I went down this rabbit hole of it saying I couldn't connect from Canada. And finally, we got around that and I got in. So nice to see you guys. And I'm hoping to be home for that July meeting. And then I'll come back to Canada. So I won't subject you at least to this nonsense next month anyway.
That sounds good. No apologies needed. It all worked out. And two of you got to, well, I was gonna say two of you got to share your first meeting, but just Julie. So it's still, you still have your turn coming up.
Right.
Thank you and see you in July.
I think Julie surpassed all expectations and ought to be nominated. So.
Oh, sure, she's accepting that. So, thanks, Ed. Bye.
See you guys later. Good night. Good day.